Retable 65 of 2022. As the judgment dated 17/2/2021 was challenged by the state, the same is pending while no stay has been granted, as a result of which the time-bound advancement scale of pay of the petitioner has not yet been released. He has retired since 2019 May.
Notice has not been issued in that.
Notice has been issued. I have also entered appearance.
Okay.
It was listed once before the then Honorable Chief Justice. It did not reach.
2000.
Another my lord, 2017 matter against the order of London State Administrative Tribunal. It was listed, it was heard, it was thereafter it has not been listed, my lord.
Retired since 2012.
Okay.
19 matter. RSCP and revision of
Appellant number, it's a conviction with 302 IPC Center Life Imprisonment. Appellant number 2, 3 are husband and wife. Two appellant husband to Malat suffered from cardiac arrest and he is shifted in hospital. Now Malat, I have filed an interim application for wife. In spite of that, Malat, your lordship passed the order for registering. It has not come. Malat, yesterday Malat husband died. Marriage, wife the rituals merely because one of the benches of Honorable Justice B. Nursing. That is why it has not been listed. Malat, last 1 week. Good saptala chesta kori even
notice kar wait
Aye.
set of the matter
Marriage
Kali Morchi
Kali Marriage hospital
all right
rituals wife ta tar rituals mein
Barta ho diyo Amita Morji you give the information to the
yes.
So that they will also ascertain.
Okay.
Would SC medical college?
SC medical under police custody he was undergoing treatment.
Case number ये data the नाम का लेकिन को
You filed the IA or you filed it today?
Already IA filed
Kebe?
hospital ରେ ଥିଲା ବେଳେ ଗୋଟେ week ପୂର୍ବରୁ mention କରୁଛି
death ର ଗୋଟେ affidavit ଦିଅନ୍ତୁ अरे death ହେଲା ବୋଲି ଗୋଟେ affidavit ଦିଅନ୍ତୁ ତାପରେ instruction ନେବେ ନା କଣ ହେଇଛି ଆପଣ information ଅନୁଯାୟୀ ଦିଅନ୍ତୁ ସେ check କରିବେ ସେଟା
advocate clerk करो on basis of telephonic information वाली दे दियंतु
so that it will be ascertained and otherwise it cannot be
ହେଇଯିବ ନା
we are listing this matter at 12 o'clock it will be taken off but do the needful otherwise how can the
yes. 12 hour na 12:30 କୁହନ୍ତୁ
12:30
ହଁ
12:30
Writ Appeal 177 of 2020, Your Lordship. The services of the petitioner were terminated. Your Lordship was working as an individual. It is 2023 matter, Your Lordship. Fresh admission. Because tomorrow.
Pardon to mention, my lordship, the petitioners are the owners of the claims, my lord. And the EC, environmental clearance, and the mining plan had already been issued in favor of the petition. But the lease agreement has not been issued by the competent authority. So the non-consideration of representation which was written in this matter.
This is under the OMMC Act or the OTLS Act? Then mining matter. Mining Mr. Counsel, please, one moment. Mining is related to you, List of appropriate bench for
ଏଟା ବୁଝି ଦେଇକି କରିଦେବା history ହେଲା ଯଦି ଆମର ଆସୁଛି ଗୋଟେ ମାସ assignment କିଛି ଇଏ କରନି assistant
This might not be the assigned bench, so
mining
find
matter
out.
କୋଟା ଅନ୍ୟ bench ରେ ଯାଉଛି ତ ସେଥିପାଇଁ maybe yes
IA file for PRLA number 341 of 2020. IA file for
bail application
supplemental list. Item number 1.
The lordship is a contempt application. We've also, meanwhile, brought the new people on record by filing an IA. But I think it is not on record, but it's already been filed. Copy also has been served. We have additional copy also. But your lordships had last time asked them to take instructions.
We have asked him that you filed this contempt petition in 2022 and you have given some names there.
Yes, sir.
So obviously, and also said that those persons might not be as the sub-collector, tahsildar. So you wanted to take instruction on that. You have the present sub-collector Sambalpur and tahsildar Sambalpur Sadar. That is the order reflect.
Yes, we have, in fact, for the amendment of the content, we have to amend the cost title. So we have also filed an IA to amend that.
So what? How many IA you have filed?
One IA.
What is the number?
68. It is probably not there on record today, but we have additional copies.
68 of
25.
2025. And you have received the copy of that IA. So let it come on record. Tomorrow we can take it up there.
Tomorrow, you should take it come on Monday.
Monday, all right. You have filed that IA for amendment of the cost title.
So that the correct persons can.
All right. The Mr. Swami Ratho, learned senior advocate, advocating for the petition that she has filed an interim application which has been registered as IA number 68 of 2025 for correction of the cost title, for amendment of the cost title. And stop. The Land Council for the State submit that he has received the copy of the interim application. As faithfully this matter on 17th of February 2025. I will be placed on the court.
Item 4.
Achha, it is to come with WPC numbers 1. Yes. Yes, Mr. Ratho.
There is already one conversion your lordship had directed earlier in this petitioner's case. That is WPC number 2944 of 2000. That was filed regarding discharge. This is during this. I had initially filed this petition challenging the order of cognizance and the proceeding. And in between the discharge petition he had rejected. So therefore that.
So now this petition is you can withdraw it because the list pendants development has taken place and it has gone to the stage of rejection of your discharge petition. So at this stage, this cognizance challenge, that is
initial this because without sanction,
because all these points you might have taken also in that subsequent application.
The problem which I am facing is that the charge sheet and everything has been scanned in this petition. The entire thing I have given on record. So in the other case, this charge sheet and complete charge sheet I have not furnished. So in this case, I was banking upon to argue before your lordship. The other case,
because there is a subsequent development, will not entertain this.
No,
we'll just dispose it of.
My lord, can I pray that this I may be also allowed for converting this petition also?
Because the Land Council for the petitioner submits that he intends to file an interim application for conversion of this application to CRL REV.
CRL REV. Final order.
Matter be the matter be listed after the interim application is filed. Yes, next.
The date may be only short date.
And upon file karibe jemti pora kuhala jemti immediately after the IA is filed, it will be listed. File karantu aji IA kali gote memo dei diyantu ki mana koruchi.
And the other case is a connected matter, my lord. There is a Sandhyanani ta sahita aschi. Seita setare gote interim order ta continuity pe I pray. Without because that interim order continuity only I will pray for that.
Sandhyanani interim order achi.
My lord had passed.
Last date pass ହେଇଥିଲା interim order
22/9/2023
ଆପଣଙ୍କର ଅର୍ଡରଟା ପରା ଏଇଠି ଅଛି ଯୋଉ ମୁଁ
ପୂର୍ବରୁ ନଥିଲା କିନ୍ତୁ ଆପଣ
ଏଇଟା ଥିଲା ମଝିରେ ସେଟା ଡିସକାଉଣ୍ଟ କାଇଁ ସେଟା ୱିକ୍ ହେଇକି ରହିଲା ତ ସେଟା ଏକ ହେଇ ପାରିଲାନି କେବେ
ସବୁ ଅର୍ଡର ସବୁ ଇଏରେ କଣ୍ଟିନ୍ୟୁ କରୁଥିଲା ସେଇ ଗୋଟେ
ଗୋଟିଏ ଡେଟରେ କଣ୍ଟିନ୍ୟୁ କରିପାରିଲା
ସେଟା ଅର୍ଡର ଟିକେ ସ୍କାନ ହେଇନି ଅର୍ଡରଟା କାଇଁ
ତା ପୂର୍ବରୁ ଏଣ୍ଟ୍ରି ମୋଡ ଗୋଟେ ଥିଲା
नहीं लास्ट डेट इज 15/11 स्कैन है नहीं कि लास्ट ऑर्डर टा
21/2/2023 ରେ ଗୋଟେ order।
15 ଆଉ ଗୋଟେ ଅର୍ଡର ହେଇଛି ତାପରେ
ତାପରେ
15
15
ଆମେ
ଏଗାର
ତାପରେ ଗୋଟେ କଣ୍ଟିନ୍ୟୁଟି ହେଇଛି ଯେ ମାଇଲର ଜଷ୍ଟିସ କେୟାର ମାପରେ ତାକୁ ଅର୍ଡର ବି କଣ୍ଟିନ୍ୟୁ।
ଆଚ୍ଛା ସେଟା ନାହିଁ
ସ୍କାନ ହେଇନି ଅର୍ଡର ଗୁଡା
ଦେଖି
ଆଗ ପଛ ହେଇକି ସ୍କାନ ହେଇଛି ନା କଣ ପେପରଲେସ୍ ହେଇକି ଗୋଟେ ୟୁଜ
ଏଇଠି ଆଉ ଗୋଟେ
ଆପଣଙ୍କ ପାଖେ ଅଛି ଯେ ଆମର ଏଠି ନାହିଁ
11/9/2023 order।
11/23 ଅର୍ଡର ଆମ ପାଖରେ ଅଛି
11 11 ତ ଅଛି ଇଣ୍ଟ୍ରିମ୍ ଅର୍ଡର 11 ଅଛି 22/9 ବି ଏକ୍ସଟେଣ୍ଡ ହେଇଛି
ତାପରେ
15/11 ଏକ୍ସଟେଣ୍ଡ ହେଇନି
ନାଇଁ ମାଇଲର
15/11
ତ ତାପରେ କାଇଁ
15/11 ପରେ ଆମେ
ଆଉ ସେ କେସଟା ୱିକ୍ ହେଇକି ଆସିଛି ତ ଆଉ ଟେକ୍ ଅଫ୍ ହେଇପାରିନି।
ଆଉ କହିଲେ ଯେ ଆମେ ଏକ୍ସଟେଣ୍ଡ କରିଦେଲୁ ବୋଲି
ନାଇଁ
ସେଟା ଆଉ ଗୋଟେ କେସ୍
ହଁ ଆଉ ଗୋଟେ ଏଇଟା
15/11 ପରେ ମିଷ୍ଟର ରଥ 15/11 ପରେ there is no extension order either on 15/11 nor thereafter it has also been
no because
taken off.
yes it has not been taken.
And you also here what have you challenged here?
Here the discharge against the order of
So
discharge
same thing.
ସେଇଟା ଆପଣ ଗୋଟେ ଆଗରୁ ରିଭିଜନ ଆପଣ ଶୁଣିଥିଲେ ସେଇଟାକୁ କୋର୍ଟ କହିଲା ଯେ କନଭର୍ସନ କରିଦିଅ ରିଟ୍ କୁ ଆମେ ପୁଣି କନଭର୍ସନ ଫାଇଲ କରିଥିଲୁ ସୋ ସେଟା ଟିକେ ଆପଣ ଦେଖିଦିଅନ୍ତୁ ସେଇ ଅର୍ଡରଟା ଟିକେ ଦେଖିଦେବେ ଯଦି ପୁରୁଣା ରିଭିଜନ ଟା ଯଦି ଆପଣ ମଗେଇଦେବେ ଫାଇଲଟା ସେ ଅର୍ଡର ସିଟ୍ ବି ଆପଣ ଦେଖିଦେବେ
କୋଉଟା କହିଲେ
ଏଇ ଯୋଉ ସନ୍ଧ୍ୟାରାଣୀ ପ୍ରଧାନୀରେ ଇନିସିଆଲି ଗୋଟେ ରିଭିଜନ ଫାଇଲ ହେଇଥିଲା ଚ୍ୟାଲେଞ୍ଜ ହେଇଥିଲା ସେଇଟା 2-3 ଥର ଶୁଣାଣି ପରେ ତାକୁ କହିଲେ ଯେ ଭିଜିଲାନ୍ସ କାଉନସିଲ ଯେ ସେଟା ରିଟ୍ କୁ କନଭର୍ସନ ହଉ କାହିଁକିନା ସ୍ପେଶାଲ ଷ୍ଟାଚୁଟ କେସ୍ ବୋଲି ତାପରେ ସେଇଟା ପୁଣି ରିଟ୍ କୁ ଡାଇରେକ୍ସନ ଦିଆଗଲା କୋର୍ଟ ଡାଇରେକ୍ସନ ଦେଇଥିଲା କନଭର୍ସନ ହେଇଗଲା କନଭର୍ସନ ହେଲା ପରେ ଇଟ୍ କେମ୍ ଅପ୍ ବିଫୋର ମାଇ ଲର୍ଡ ଜଷ୍ଟିସ ତାଳପତ୍ର ମାଇ ଲର୍ଡ thereafter the interim order was passed ସେଇଟା କଣ୍ଟିନ୍ୟୁ କରିକି ଚାଲିଲା କିନ୍ତୁ ପୁଣି ଆପଣ ଏବେ ଯଦି ଆଉ ଗୋଟେ ରିଭିଜନ ମୁଁ କନଭର୍ସନ ଯଦି କରିବି ଯଦି ଆପଣ କହିବେ ତାହେଲେ ମୁଁ କନଭର୍ସନ ଆଉ ଗୋଟେ ଫାଇଲ
କରନ୍ତୁ ଆମେ କହିବୁନି you have now what was the discussion last time that it is not the special court act order
ଆପଣ ଆପଣ ସେଇଟା that is very clear with your ମଧୁଲିମା କେସ୍ ଆଉ ସବୁଗୁଡାକ ଧରିକି ଆପଣ ଦେଇଛନ୍ତି ଜଜମେଣ୍ଟ ଦେଇଛନ୍ତି ଶୁକ୍ଲା କେସ୍ ବିସି ଶୁକ୍ଲା କେସ୍
he intends to file an interim application and same order it will be listed immediately after the interim application. Yes.
ମାନେ interim order to continuity ଟା ଟିକେ କରେଇ ଦିଅନ୍ତୁ
ବର୍ଷେ ହେଲା ନାଇଁ
ନାଇଁ ସେତିକି that is not my fault ଏବେ ଜଷ୍ଟିସ ଷଡଙ୍ଗୀଙ୍କ ପାଖରେ ଉଠିଲା ସିଏ ସେଟା ରୋଷ୍ଟର ନଥିଲା ସେଠୁ ସେଟା ଚାଲିଗଲା he did not I did not pay for it because that was he
file an interim application let it come on that day we'll see that. Yes.
Item 3.
Yes, Mr. Dan.
my lord permitted to withdraw liberty to file better application.
ଫ୍ୟାମିଲି କୋର୍ଟ ର ଅର୍ଡର ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଏଇଠି କଣ ଆସିବ ନା ଭୁଲ ଜଜମେଣ୍ଟ ଦେଇ ଦେଇଛନ୍ତି ସିଭିଲ ସୁଟ ମାଟାର ଇଏ ଆମ ପାଖେ ଆସୁଛି
Item number 321.
ହଁ
Item number 321. You WPC.
ହଁ ସେଇଟା କଣ ମାଟା ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି
No.
Page 30 is what is challenged.
Annexure
Annexure
3
4.
Annexure 3 ଟା କଣ ଦେଲେ divorce ଏଟା
Trying to prove that the
ଓହୋ
divorce application was finalized on 17/8/21. But according to customs, before that, they had already been divorced. That is his case. He wants to withdraw to file a withdraw.
ଓ anyway ଛାଡ
Yes, next. Memo ଦେଲେ ତ?
ନା ଦେଇଦେବି
ଲେଖିନି ଦିଅନ୍ତୁ।
Item 4.
Item number 4, may I please, Your Lordship. Hello, this is
Yes.
item number 4, my lords. This is regarding a compensation matter for land acquired by Mahanadi Coalfield under the Coal Bearings Act. And Your Lordship, this writ is filed pursuant to the directions of the Honorable Apex Court. The order has also been annexed to the writ application. Here, my lords, I am challenging Annexure 2, page 22, the judgment passed by the Learned Claims Commission, by which my claims case was rejected because I was found absent on that particular date. My prayer is for structure compensation.
You are challenging the order dated 24/5/2018.
24/5/2018,
That
page
is annexure.
Annexure 2 series, my lords. Annexure 2.
Okay. So now the claim commission is not functioning.
Commission is not
So who
functional.
are the opposite parties here?
The opposite parties are state, collector, Mahanadi Coalfields, and I have made the commissioner party, but my lord's notice need not go there.
So these are the parties before also the claim commission.
So before the claims commission, the party is of course Mahanadi Coalfield, because Mahanadi Coalfield is a project proponent.
So this to set aside this order, why have you added more parties who are not the parties in before the claim commission?
My lord, state is the party here, state of Odisha.
No.
And
in the first paragraph, it is mentioned that so appears for MCL and files wakalatnama, same is taken on record. But you were found absent. And you also said that there is no other party in before the claim commission except
except Mahanadi.
except MCL.
That is the
So
procedure.
now you have added
my lords, then may I be permitted to
district and magistrate. You have added additional district magistrate.
Yes, my lord, because my lords, they are the dispersing authorities under the RNR Act 2013, which is why, because they are proper parties, I have added them to this writ application. Because my lords,
Now, if we allow you writ petition, what we can do? We have to just the matter would be restored. Let us say
my lords.
That would be the order.
No, my lords, your lordship may see the order of the Honorable Apex Court at page 31. Yes. Any issue, my lords, your lordship may take page 31, my lords, sorry, 31. This is 10/10/2023.
No, we are not on that. You are coming with a particular prayer to set aside the order dated
24/5/2018.
24/5/2018.
Yes, ma'am.
Now, let us say we set aside the order. Now the matter will be restored, but the restored authority is no more in existence.
Is not functional. So
in view of the respondency development, are you not supposed to file an interim application for amendment of the this writ petition, that also after the it is restored, the take of the other issues which we are challenging before the claim, that also be taken up, because there is no other forum available to you now.
My lords, the only forum is before my lords, because that is the order of the Honorable.
So unless you make a prayer in that way, your writ petition is
my prayer in the writ is not to just set aside, but I've also made specific prayers to grant me compensation. Your lordship may see page 13 of my brief. My prayer number 2 is to direct the opposite party MCL to make assessment and grant compensation for that structure.
This matter notice has not been issued.
No, my lord, it's a fresh matter. And I believe, my lord, this matter was filed before the order of the Honorable Apex Court, by which the Claims Commission has been.
No, that was the recent
that was the. I have copies, my lord.
4th of January.
January, I have copies, my lord.
This was filed.
No, this was filed. I'm sorry, my lord. I stand corrected. This was filed after that.
This petition has been filed by the petitioner Arun Carlson in prayer to set aside the order dated 24/5/2018 drafted by the opposite party number 4 Claims Commission in claim case number 181/1. In dismissing the claim case, as the petitioner was found absent on repeated call on the date fixed, the Land Counsel for the petitioner submits that in view of the decision rendered by the Honorable Supreme Court in the case of so and so, since the claim commission is not functioning, after the said order is set aside, this court has also to consider the prayer which has been made in the writ petition regarding direction to the Mahanadi Court field opposite parties also to make number 2 and 3 date of court issue notice on the question of admission indicating therein the matter shall be disposed of at the stage of admission. No notice be issued to opposite party number 4 and counsel for the state accept notice for opposite party number 1, 4 and 5 and 6. So far as opposite parties number 2 and 3 are concerned, the requisites for issuance of notice by speed posted to delivery shall be filed within a week. Matter be listed after 4 weeks. Counter affidavit can be filed in the meantime. Please give that reference that
The Supreme Court.
ଏତେ ଦରକାର ନାହିଁ ଆପଣ ଖାଲି just
ଗୋଟେ କପି ଦେଇ ଦଉଛି ମୁଁ
copy
ନେଇକି ଆସିଲି
ଯୋଉ then commission
3rd January.
reference level.
Grateful notice.
Item 5.
The petition is challenging the compensation amount which is not given by the opposite side. Similar order, similar matter disposed of by the Supreme Court.
First date allowed.
No.
Okay, this will consider
Why the compensation of listed of the acquired land under Annexure 2? What is Annexure 2?
Annexure 2.
So how this type of order has to be passed unless notice is issued and it is ascertained that your land has been acquired and no compensation has been paid, all these things, how can directly we pass this order that give this amount to the...
It's 9.
Merely because the state council will concede, we will pass the order, and then they will pass a review saying that the state council did not have instructions.
And it is order number 1.
Right, we'll also look at paragraph 13 of page 9. Paragraph 13, my lord, second line. Those the petitioners requested the authority for payment. Though the petitioners requested the authority for payment of compensation as he has lost the entire land, so the opposite parties are not taking any steps for payment of compensation. In other words, the opposite parties are avoiding the petitioner, denying the payment of compensation to the petitioner. When did he apply? When did they deny? These details are not here.
There may be basis for denying the claim.
But the date of application and to whom it was applied, when did they reject? All these things.
Where is your application?
Then? Because it is covered, so nothing is required. You will concede and we will pass the order.
The file those applications. This writ petition has been filed by the petitioner. Vaikunthranath Bari. Entirely with the prayer for payment of for a direction to the opposite party to pay compensation in respect of the acquired land under Annexure 2 in favor of the petitioner and other benefits to which the petitioners are entitled to. The Land Council has filed an order of this court passed in WPC number 12225 of 2023, order dated for 22/5/2023. Order number 1 dated so and so, in which the compensation amount has been directed to be paid to the claimants within a period of 4 weeks in the light of the order passed in Damodar Rautray versus land acquisition, collector, cutter. In order dated for example 26/3/2011 in LA case number 3 of 2008. However, in the writ petition, averment has been taken in paragraph number 13, where the petitioner requested the authority for payment of compensation as he had lost the entire land, but the opposite party are not taking any steps for payment of the compensation, and the opposite parties are avoiding the petitioner and denying the payment of compensation to the petitioner. The application, which is stated to have been filed before the authorities for claiming compensation, is also not annexed to the writ petition. So, we are not we are of the view that the type of order which has been passed in WPC number so and so cannot be passed in this case without detailed particulars and counsel for the petitioner seeks permission to obtain instruction and if necessary to file interim application for amendment of the petition. This is adjourned. This is matter on such and so forth.
6, 7 of same.
Same in item number 6 and 7.
Much of it.
Item 8.
May approach. The petitioner the measures and discuss family related to the other benefit matter has approved the authority and accept 3 and 4 months. The same has not been considered matter. In identical case, he not been
Grievance petition you have given.
Madam,
Before whom?
before the director as well to the
What is your grievance?
demands for
You have not been paid
RR benefit.
RR benefits in terms of 2006, sir.
Yes, ma'am.
And that has been made on 23/3/2024.
Madam. First, on
Zam Naik is one of the signatory.
yes, madam.
Who are the other persons?
What other 3 person have filed earlier writ petition before Ratho and Ratho have disposed of the matter passing Ratho.
Person. এই ଯୋଉମାନେ ଦସ୍ତଖତ କରିଛନ୍ତି annexure 3 ଆଉ 4 ରେ ସେମାନେ separate writ petition file କରିଥିଲେ ଏଇଭଳି prayer ପାଇଁ ନା କଣ?
ସେମାନଙ୍କ ଭିତରୁ 3 ଜଣ ଫାଇଲ କରିଥିଲେ
କାଇଁ କଣ order ହେଇଛି?
directing to consider their representation as 3 and 4 one.
ये ଦେଇଛନ୍ତି representation ବୋଲି କିଛି ଲେଖିଛନ୍ତି କୋଉଠି registered post କି ହାତରେ ଧରାଲେ କି
Registered post.
email
ଅଛି କିଛି document?
government
Deputy Director Aran.
so who will dispose 2 or 3 or both will dispose
Both will.
both given nahi who is the person who will take a decision
Director.
Director means opposite party number
2.
2. এটা কাটিয়ে দিলাম।
na deputy director এটার আছে deputy director
এটা হচ্ছে Deputy Director করতে পারছিল এগুলা 2 নম্বর হচ্ছে Deputy Director ছিল আগে Deputy Director করতে না আগে
come additional secretary ko
শ্রীযুক্ত নির্দেশক is it the same representation which
Same,
is
same bunch.
based in research also
କରିଦବ ଗୋଟେ ଲାଇନ ବି ଲେଖିଦବ ଯେ ଆମେ ଗୋଟେ ରିପୋର୍ଟସନ କରିଥିଲେ ସୁବିଧା ସ୍ପନ୍ସର କରିଥିଲେ ଏଇଟା ସାଙ୍ଗେ ସୁବିଧା ହବ और इसका टेक ऑर्डर हो একটা এক্সট্রা ডিটেল লাইন থাকে
So in this petition, the petitioner Subham Naik has prayed for direction to the opposite parties for extending the rehabilitation assistance benefit as a displaced family under Para 2D of RR Policy 2006 in favor of the in its favor by considering the grievance under annexure 3 and 4. The Grand Council for the Governments that annexure 4 was submitted before the opposite party number 2, and apart from the petitioner, the other signatories are Duti Naik, Prashanna Naik, Pavitra Naik, who approached this court in WPC number 0904 of 2024 for a similar with a similar prayer, and the said writ petition was disposed of on 5/9/2024, directing the Deputy Director R&R from Additional Secretary, Department of Water Resources, Bhubaneswar, and Special Land Acquisition Officer, Bengal South Side Canal, Mahisa Patin Canal, to consider the representation in accordance with law within stipulated time from the date of production of the certified copy of the order. It submits that the similar order may be passed. In this case, he has produced the copy of the order dated 5/9/2024 in the aforesaid W writ petition, which is taken on the call. Land Council for the state has no objection, taking into account the nature of relief sought for, and since the representation is stated to be pending before the opposite party number 2, while annexure 4, without expressing any opinion on the merits of the representation, we dispose of the representation, directing the opposite party number 2 to consider the representation in accordance with law and dispose of the same within a period of 3 months from the date of production of the certified copy of the order by the petitioner, and communicate the order to the petitioner within a period of 2 weeks thereafter.
Eight, nine also same, madam.
8, 9 same. ସେ ଲୋକଗୁଡାକ ନାଁ ଥିଲା ସେ ରିପ୍ରେଜେଣ୍ଟେସନ
Same, madam.
both are son of the 8, 9 ଆଉ ଗୋଟେ କୋଉଟା
8, 9. Only 8 and 9.
ଦିଟା ବାଟ ଆଉ ଗୋଟେ ହଉଛି 11
was separate.
ସେପାରେଟ
Item 10.
After approach before the authority under section 64 of RHCL Act,
yes
direction of giving to authority land acquisition, rehabilitation and resettlement authority factor under section 51 of Act.
which provision
51.
that is your book
Body to
take up put up this matter next week as prayed for.
tomorrow politics.
Yes. It's unfortunate that
Kindly see.
yes next no, we'll not sit.
Item 11.
Already
Yes next item number
Item 11.
May I? The hearing this case, madam. What is the order of this order is one, my lord. The enhanced compensation has been sanctioned double petition as at annexure 2, my lord, page 14, my lord. And accordingly, the loan officer has taken the 60 houses from petitioner, my lord, as at annexure 4, my lord. But the said amount has not been paid to the petitioner. In the meantime, more than 6 months have gone. Therefore, petitioner approached the authorities, my lord, as at annexure 5,
Hmm.
5 and 6, my lord.
5 and 6.
My lord.
What you have stated there?
The amount has been, the enhanced compensation amount has been sanctioned in favor of the petition, my lord. And the zone
What
of
is that? It has been sanctioned
yes,
and yet not disbursed.
not disposed to the petition.
No, this sanction kind order.
Your lordship can say annexure 2, my lord.
Annexure
2.
I think one similar matter we have disposed of yesterday, if I remember. Common order passed in 3 applications. Where is the order?
Sanction order, the other annexure
Not
2.
sanction order, the judgment. That you have not given. Award. Kiran Chinada, something familiar.
The award, the land action has filed before the land action appeal, and this one would have
list
disposed the appeal as at annexure 1.
ଦରକାର ହଉଛି ଥରେ ଦେଖିବା ପାଇଁ ତ ୱିକ୍ ର ଲିଷ୍ଟ ରଖିଦଉଥିବେ ଆଧାର ଗୋଟେ ଫୋଲ୍ଡର ଗୋଟେ ବିରଞ୍ଚି କାଲି ଥିଲା ବୋଧେ ଆପଣ କାଲିର ଲିଷ୍ଟ ଅଛି ଦେଲେ
Oh, you sign annexure 5 it was adjudicated by the Civil Judge Senior Division Atmali
Yes,
hearing LA number so and so.
my lord.
ହେଲା ସେଇ ଅର୍ଡରଟା ଦରକାର ହଉଛି ଏଟା ଆପଣ ଆନେକ୍ସ କରୁନାହାନ୍ତି
Annexure 4 ଟା may clear down.
Against that order, the
Annexure
land action
4
has preferred appeal before this one court, my lord.
ସେଇଟା ହେଲା
That has been adjudicated by this one court, that is annexure at 1, my lord.
annexure 1
My lord.
ଯଦି ସେଇଟା କାଲି ଯଦି ସେଟା
Paragraph second mentioned as LA miscase number 110 of 2011, my lord.
I may be mistaken ମତେ ଲାଗୁଛି disposal କୋଉଟା ସେଇ order sir
Annexure 1, my lord.
ଏଇଟା ଦିଆ ହେଇଛି ଦିଟା LA କେସ୍ ରେଫର ହେଇଛି annexure 5 ରେ whereas this annexure 1 it relates to one case only that is 110 of 2011 so what about the other case which you have referred ଆପଣଙ୍କର you come to annexure 5
My lord.
annexure 5 रे you have said that 2 LA cases have been disposed of by the Civil Judge Senior Division at Mali, right? And on the basis of the orders passed in those 2 LA cases, you have given the amount also that in LA case number so and so.
ଦି ଜଣଙ୍କର ଅଲଗା ଅଲଗା ଏମଏ କେସ୍ ଦି ଜଣ ଥିଲେ
ବଟ୍ annexure 5 ରେ କିଛି
Yes.
ଲେଖୁନାହାନ୍ତି appeal file ହେଇଛି ବୋଲି ଆଧାର କିଛି ନାହିଁ
ଏଥିରେ ଅଛି ଏଗୁଡ଼ା
annexure 5 ରେ ନାହିଁ
annexure 4 ଟା
A petitioner କିଏ ତା ନାଁ କଣ?
annexure 1 is the
ଏଇଟା
specific
ହେଲା ଅବନି
ଅବନୀ
annexure 1 ରେ ସେଟା the government of Orissa has already
ଅବନୀର ହଉଛି LA case number 110 of
110 by
2011.
11.
Hey, just a minute. By later dated so and so in favor of Aboni and others corresponding to LA number so and so. Acha. He said sanction decretal amount additional so and so. Odisha has also reflected in the head of the account from which it is debitable and supplied the order to the concerned authorities for information and necessary action. And the authorities so and so had also took CC voucher from the clients in May 2024 and since long not been paid, release the decretal amount without intimating the reason not releasing that my clients want to using interest action. So if the money has been sanctioned and the government has preferred land acquisition appeal, that is annexure 1, and that has been dismissed also, and the order has been
get instruction.
Annexure 1 is just clearly indicated.
Yes, yes.
I will take inspection of
that would be better. This writ petition has been filed by petitioner Pani Kumar Behera with a prayer for a direction to the opposite party for disbursement of the sanction amount of rupees 13,58,763 towards payment of decretal dues with interest. The Land Council for the petitioner submits that the petitioner filed petition under section 18 of the LA Act 1894 against the LAZO Zone 1 RRCS Baghua Bor Talache, which was adjudicated by the Land and Civil Justice Senior Division Atmali in LA case number 110 of 2011 in favor of the petitioner, and on the basis of the order passed by the Land and Civil Court, the additional secretary from Director R&R Government of Orissa Department of Water Resource, Rajiv Bhavan Bhubaneswar, Orissa, filed letter number 15612 dated 30/5/2022. 35/2/2024. A sanctioned amount of rupees 13,58,763 in connection with the aforesaid LA case number 110 of 2011. And after receipt of the said order from the additional secretary, the LAZO Zone 1 RRCS Maishapa Dhenkana took the CC vouchers from the petitioner in the month of May 2024. And it was submitted before the special LAO from RRCS Dhenkana for releasing the decretal amount, but till date, no decretal dues has been paid to the petitioner. The Land Council for the state took some time to obtain instruction in the matter. Put up this matter. Kebe rakhi wa kontu? 1 week after. 24 tarikh. This matter in the week commencing from 24th of February 2025. Free copy of the order be handed over to the Land Council for the state. Yes.
Item didn't come to.
ଆର ସପ୍ତାହରେ କରିଥିଲେ ନା ମାର୍ଚ୍ଚରେ କରିଥିଲେ 10th March. Yes.
Sorry.
Item 12.
Yes, ma'am.
May I please you? The petitioner is a casual worker, my lord. He was worked since 2012, my lord, as per annexure 1, my lord. He has filed a petition before the central tribunal regarding regularization of his service.
You are free to set aside the order of the Land Central Administrative Tribunal that is dated 4/9/2024 in OA number 101 of 2017, annexure 8. Please come to that into order.
In that order, my lord, at the last 56, my lord, paragraph 6.
No, just read the few lines from the first paragraph itself, then we'll go to that. What is the actually your prayer in that?
The applicant
original
has filed away praying for quashing the order of a CBDT dated 13/5/2013, circulated by letter dated 16/5/2013, and to direct the respondent to regularize his service against any group C vacancy, taking into consideration his educational qualification. Until such regularization, respondents may be directed to continue disbursement of salary of the remuneration, inter alia stating that he is a matriculate and was engaged on casual basis from 1/9/2012. The work performed by him is perennial in nature. Similarly situated employees approached this tribunal in ON number 377/2013, which was disposed of by the order dated 5/2018, with direction to the respondent to adopt the ratio as has been observed by the CAT Principal Bench, New Delhi, in ON number 2012 of 2013, dated 22/4/2014, and therefore the case applicant being same, his ON may be disposed of with a similar direction to the respondent. It is stated that similar set of employees approached the CAT PB bench in ON number 81846/2013 on the strength of interim order dated 29/5/2013 passed by the CAT.
All right, you come to the operative part, paragraph 6.
Paragraph 6. It is not the case applicant that his initial engagement was after following the process of selection as per the rule or against any sanction post. The engagement of the applicant, as admitted by him with effect from 1/9/2012, do not fall within the scope and ambit of exceptional clauses for one-time relaxation, as made in the decision of the Honorable Apex Court in Umadevi. The applicant has not completed the 10 years of service as on the cut-off date, that is 2006. We have gone through the decision relied on by the applicant, that we find that in view of the decision of
Since when you are in, sir?
I'm a 2012 man. Umadevi case is a long back, my lord. And this Umadevi case has in recent judgment as reiterated by the Apex Court.
What is that judgment?
Decision.
Where is that judgment?
Well, I'm saying. Paragraph 14.
Have you placed this judgment before the?
At that time, the judgment is not pronounced. And your lordship has in similar case has already been admitted as anti-interim order.
Just let us. हमें जो ऑर्डर पास करते लोग दियों तो आपसे जो ऑनरेबल सुप्रीम कोर्ट को ऑर्डर कर वो पैराग्राफ था
पैरा 14 में your lordship sir
देखिए
लास्ट पेज ला देना है ना कौन कौन है जमना ना लास्ट पेज ला नहीं तो ये पेज 23 था तो खाली लास्ट पेज ला रखते बाकी करेगा
allowed some registration.
हमारे जैसा करेगा स्टेपला टाका
Notice का
हाँ नोटिस सिमिलर मैटर
This petition has been filed by the petitioner Satyaranjan Malik, challenging the order dated 4/9/2024 of the Central Administrative Tribunal that has been set up in OA number 260/00101 of 2017, wherein taking into account the ratio laid down by the Honorable Supreme Court in the case of Secretary State of Karnataka and others versus Mahadevi and others 2006 code SCC page 1, and with further observation that the engagement of the petitioner with effect from 1/9/2012 does not fall within the scope and ambit of the exceptional clause for one-time relaxation as observed in the said case, and that the petitioner has not completed 10 years of service as in the cut-off date, that is 2006. The original application was dismissed. The land counsel for the petitioner submitted that similar matters are sub judice before this court in WPC number P0384 of 2024. The case of Prashant Kumar Malik versus Union of India, in which notice has been issued.
My Lord, I am appearing for the opposite control 1 and 2.
In which the land counsel for the Union of India was asked to obtain instruction in the matter. The copy of the order is filed, which is taken on record. The land counsel for the petitioner further brought to the notice of this court the decision rendered by the Honorable Supreme Court in the case of Sripal and another versus Nagar Nigam Ghaziabad, in civil appeal number 81, order dated as of 31/1/2025, in civil appeal number 8157 of 2024. Reported in 2025 INSC 144, wherein it is observed as follows, quote paragraph number 14. Issue notice on the question of admission, debating wherein that the matter shall be disposed of at the stage of admission. Mr. Bahi, along with
Ajay Kumar Rai, senior panel counsel.
Kerala.
My name already mentioned, so I will render up.
So, for opposite party number
1 and 2.
1 and 2. You have received the copy. One copy you must have received. Extra copy of the petition we served on the land council for the opposite party number 1 and 2. So far as these other parties are concerned, income tax एवढा तो notice जीवन आपण appear करिवे. Principal Chief Commissioner Income Tax, Assistant Commissioner of Income Tax एवढा आपण किए तांगरो. Where is Mr. Padi? आपण appear करतो ना कोणाला.
Service matter, service regulation of the employees of the under the Commissioner Income Tax is also then the under CGC that's in the government.
He has no instruction. That is why I'm asking you. That's why we are asking. Where is Mr. Padi? If you accept the notice for all, then there is nothing to. If you accept this income tax authorities, because the rest 4 or 5 are all income tax authorities. Party is not there.
So, my lord, I am the appearing the senior panel counsel.
Oh. So what is your instruction? You have no instruction.
So, stand country.
Not week time. The notice you also repudiate file for you upon instruction. Repudiates for issuance of notice to opposite party number 3 to 7 be filed within a week and matter be listed for each other of president. Yes.
Interim protection. Status quo may be given. It is now continued. Status quo may be given because he is still continuing.
How can we know that you are still continuing? Because in the note, the date chart mentioned that on 13/5/2013, the CBDT issued letter for requesting engagement through outsourcing. You have not also stated that you are still continuing. No, you have not stated. We have seen your interim application. Where have you stated? IA number 1 issue notice खाली करते हैं बस. Next, accept one set of SSBs.
Item 13.
13 may not similar order. Next, the homestead land or allowed the petitioner. The petitioner file a representation annexure 5 my lord.
Annexure 5 is the representation.
My lord.
What is that representation?
Allotment of homestead land, my lord, to the petitioner.
Decretal.
Annex. Pending before big fights.
Consider the events of the briefing that annexure 5 provide homestead land and profit on submitted representation. They grant representation. ସେଟା ଦେଇଛନ୍ତି କି ଆପଣ 2/12/2026 ରେ? ଆଚ୍ଛା
Same.
ଏବେ ତ ଦେଇଛନ୍ତି ଆପଣ ଛାନିଆ ହେଇ ପଳେଇଲେ କାହିଁକି? ସାଙ୍ଗେ ସାଙ୍ଗେ ଆପଣଙ୍କୁ ଦେବେ ମାନେ କାମଟା ହେଇଯିବ। କିଛି ଡକ୍ୟୁମେଣ୍ଟାରୀ ପ୍ରୁଫ୍ ଅଛି ନା ରିସିଭ୍ କରିଦେଇଛନ୍ତି?
My melody.
There is the endorsement that they are giving.
Endorsement.
Master to make sure. खाली वो लिस्ट को रिप्रेजेंटेशन डिस्पोजल वाले एंटरटेन के
Come so early. You filed the representation in December and
application
that application. Now you filed the repetition in January. So what is the judges? They have to consider your case. So many things they have to see in that whether you are entitled to not. So
inquiry has to be conducted.
Huh?
An inquiry has to be conducted.
And if we
don't find any necessity, but if there is undue delay, it's okay for him to approach the authority itself.
The petition has been filed by the petitioner Tini Jena.
Premature only by
Prayer for a direction to the opposite party number 5 to consider the grievance of the petitioner under Annexure 5 and to provide in homestead land in Block C, Larkipalli and Sadaipalli Rehabilitation Colony for residential purpose to the petitioner. It appears that the representation is dated 2/12/2024 and therefore it cannot be said that there is any inordinate delay on the part of the authorities in disposing of the representation. Accordingly, we dispose of this petition as premature if there is any inordinate delay in taking action under on the basis of an issue file, the petitioner is at liberty to seek appropriate remedy in accordance with law. Yes.
Would you excuse me, I don't feel well. In this paragraph 3, I have stated the petitioner unless interim order is not directed.
You have not stated
I think
specifically that till today you are continuing.
His continuously petition is granted, his engagement like.
No, that is not it. You are not, there is no such government. We have verified. Yes, next.
Item 14.
Item 14, may I please, Your Lordship. Similar order under Annexure 2, Your Lordship. Matter is related to disbursement of compensation under land acquisition.
Judgment is of 17/11/2017. Has not taken any steps for payment of the amount.
What is your prayer? Disburse the compensation amount pursuant to the order dated so and so. Why you did not come up earlier? And after that order was passed, whether there is no challenge to the said order?
Yes, I have mentioned in the petition, Your Lordship, there is no challenge to the order. There is no appeal filed by the state.
No, that is exactly what you want to know.
But you are being represented by a counsel. It is not that ex parte order.
Because the government leader appearing for the opposite party also contested the case and said that you are not entitled to and for the higher compensation and there is no merit, whatever it may be. On the merit it was adjudicated and the order was passed with a direction to so and so. So
similar order annexure 2.
Annexure 2. No objection, no objection. Sanction. So we have to get confirmation regarding that whether this order has been challenged because in view of the passage of time, right?
Yes, sir.
In that case, you made a submission that you have no objection for the disbursement. So
The other case.
that is what we have. Let's go. The petitioner Narendra Pradhan alias Pradhan has filed this petition for a direction to the opposite parties for disbursement of the compensation amount pursuant to the order dated 17/11/2017 of the Land and Civil Justice Senior Division Dharamgarh in LAR number 85 of 2012 within a stipulated time period. Since the order is dated 17/11/2017, the Land Council for the state wants to obtain instruction as to whether there is any appeal preferred against by the state against the aforesaid order dated judgment and order dated 17/11/2017 or not. Put up this matter. Kever rakhiwa kaun tu?
1 week after.
1 week after. And also to obtain instruction that if the appeal has not been preferred, why the payment has not yet been made in favor of the petitioner as per the aforesaid judgment and order dated 17/11/2017. Free copy of the order be handed over to the Land Council for the state. Yes. Matter will be listed on 24th of February.
20.
ଆପଣ ଗୋଟେ ଲାଇନ ଲେଖିଛନ୍ତି ପୁରା କଣ ଗୋଟେ ଯୋଉ ସେ appeal କରିନାହାନ୍ତି ବୋଲି କୋଉ paragraph?
It is in
huh?
paragraph number 4, Your Lordship, page number 5.
ଗୋଟେ ତ appeal କରିନାହାନ୍ତି ଆଉ ଗୋଟେ ଆଉ କୋଉ ପାର୍ଟି litigation କରିନାହାନ୍ତି ଯେ we are the rightful owner ସେଇଟା ବି you have to find out ନା.
Yes, the claimant is the recorded tenant in the court.
No, ଆପଣ କୋଉ ଲେଖିଛନ୍ତି ଯେ state appeal କରିନାହାନ୍ତି ବୋଲି?
Yes, sir. Paragraph 4 last line.
As a good line has been in the writ petition in paragraph number 4, it has been mentioned that it is the petitioner has ascertained that the opposite party did not choose to challenge the award before this court. After literally she wants to obtain judgment. Yes,
Item 15.
Mr. Behra.
Item 15, madam.
No, 15 per Mr. Mishra, here.
May please, this petitioner is a landless person, my lord. And he has.
You want representation to be disposed of.
Madam.
What is that representation?
Madam, simply he has stated that the land be settled in his favor.
Really,
No, okay, what's the
Annexure 1 is the representation, Your Lordship. One OPL proceeding was taken up against him, and he has not taken the statutory remedy where the land can be settled in his favor. Rather, one representation has been annexed, which is that annexure.
File an application under section 8A. Representation re kon
7 and 8
High Court order.
And annexure 1, whether that has been addressed to someone or not, that is no endorsement or no receipt has been given.
Clearly, what matters that notice was served in 2001.
It is an encroachment case or not?
It was in
encroachment case re tar jar number hochi 452 of 2001 ଆପଣଙ୍କୁ show cause notice issue ହେଲା ସେ show cause notice ରେ ଆପଣ reply ଦେଲେ 2024 ରେ ହେଲା ଆପଣଙ୍କର prayer ଦେଖନ୍ତୁ ତା ଦେହରେ କଣ ଲେଖିଛନ୍ତି ଯେ କିନ୍ତୁ ଉକ୍ତ ଜାଗାରେ ଶୁଆଂଶୁ ହେଇଥିବାରୁ ଜମି ପଟା ଅନ୍ୟ ଏକ ବ୍ୟକ୍ତି ଲିଲି ସାହୁଙ୍କ ନାମରେ ପ୍ରକାଶ ପାଇଥିବାରୁ ଆମର ଘୋର କ୍ଷତି ହେଇଛି ଏଣୁ ବିନୀତ ପ୍ରାର୍ଥନା କରେ ଆପଣ ସଦୟ ହୋଇ ଉକ୍ତ ଇଏର ତଦନ୍ତ କରି ଆମ ଗ୍ରାମର ଜମି ପଟା ପ୍ରଦାନ କରି ଆମେ ଚିର ଉପକୃତ ହେବୁ ତ ଆପଣ ୟୁ ଆର୍ ଆନ୍ ଏନକ୍ରୋଚର ତ ଆପଣ ସେ ଆ ନାଁରେ ପଟା ହେଲା ତା ନାଁରେ ପଟା ହେଲା ହ୍ୱାଟ ଆବାଉଟ୍ you on what basis you are seeking that this representation would have any effect at all?
No, my home is submit my lord that part of the same land has been settled in favor of the opposite party number 4.
ଆପଣଙ୍କୁ ଯୋଉ where is the notice?
But ସେଇ ଥ୍ରୁ ତାକୁ ଦିଆଯାଇଛି
ଯୋଉ notice ଟା ହେଇଥିଲା ତାକୁ ଆପଣ annexure 2 ଇଏ କରିଛନ୍ତି so ଆପଣ ତାପରେ ଯୋଉ ରିପ୍ଲାଏ ଦେଇଛନ୍ତି show cause notice ଏଇଟା ତ show cause ନୁହେଁ ଏଇଟା କଣ ଆଉ ଗୋଟେ ଅନ୍ୟ କଣ
ମାନେ OPL proceeding ଟା drop ହେଇଗଲା
OPL proceeding 2001
ସେ କଣ ହେଲା ସେଇଟା
ସେଇ ଥ୍ରୁ ଦିଆହେଇଛି ସମସ୍ତେ
ଦିଆ ହେଇଛି ଯେ ସେଟା କଣ ହେଲା କହିବେନି ଖାଲି ହେଲା ଦିଆ ହେଲା ତାପରେ କଣ ୱାର୍ଡିଂ ହେଲା ଅର୍ଡର ହେଲା ଆପଣ petition ଦେଲେ କଣ
ସେମିତି ପେଣ୍ଡିଂ ଅଛି ଆଉ
କେମିତି ପେଣ୍ଡିଂ ଆପଣ ଯଦି ଗୋଟେ 2001 ମସିହାର ପ୍ରୋସିଡିଂ ରେ ଆପଣ ନୋଟିସ ପାଇକିନି 2024 ରେ ଏବଂ ତା ଦେହରେ ତାରିଖ ଦେଖନ୍ତୁ ଫିକ୍ସ ଅପ ହେଇଛି 22/10/2002 10 ଘଣ୍ଟାରେ ଆପଣ ହାଜର ହେବେ ଏବଂ ଆପଣ ଶୋ କଜ ଦେବେ ହେଲା ଏବଂ ଜମି ନା ଲେଖା ହେଇଛି ଯୋଉଡାକ ଯଦି ଆପଣ ସେତେବେଳେ କମ୍ପ୍ଲାଏ ନ କରି ହଠାତ୍ 2024 ରେ ଗୋଟେ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେବେ how you are so sure that this PLE proceeding has is still sub judice or no order has been passed? Where is the audit?
So, I will submit this. I will submit the copy.
You will?
I will submit the copy of the order, madam, and the enforcement proceeding. Kindly put the full subject. Because my submission manual part of the same land has been given to opposite party.
Statutory remedy is available for settlement of land.
Your lordship kindly be lenient because the inquiry will take place.
No, we are not in a position to know that what is the stage of this enforcement case.
I will submit.
And that representation, whether that has been solved to the authorities or not.
सब हेले भी से representation ର ମୂଲ୍ୟ କଣ ଗୋଟେ କେସ୍ ସରିଲାଣି 20 ବର୍ଷ ଆଗରୁ
This writ petition has been filed by the petitioner Vishnu Charana Nayak with a prayer for a direction to the authority to dispose of the representation dated 27/11/2024 under Annexure 1. It appears that an encroachment proceeding was instituted in the year 2001, which is numbered as encroachment case number 452 of 2001. And the petitioner was issued notice in this said proceeding, and he was asked to appear either in person or through his authorized agent on 22/10/2002 at 10 a.m. and to show cause why he should not be proceeded against under section 4 and 6 of Odisha Prevention of Land Encroachment Act 1972, Odisha Act 6 of 1972. It appears that from the submission made by the Land Council, it appears that no show cause has been filed on the date fixed. We are not in a position to know that about the, and no receipt of the said case has also been filed before us to come to the conclusion that the proceeding is still sub judice before the
settlement. What is the fate of the
order sheet and
representation disposal?
before the Tahsildar was the Kendrapada. Since in a case of this nature, and since in view of the lack of particulars, we are not able to grant relief which has been prayed for by the petitioner regarding disposal of the representation. Accordingly, the petition is disposed of. Yes.
Given to the petitioner to
you take steps in accordance with law. If that proceeding is still pending, you appear. If it has been disposed of, if any order has been passed against you, the remedy is available under that very act. You approach the appropriate authority.
liberty be given to the petitioner to
Reporting on
approach one line be
you are rising from the deep slumber and hello.
Humbly one line be so that that person will approach the appropriate authority.
And କହିବାର କ'ଣ ଅଛି ଆପଣ you have got a statutory remedy if the order has been passed. Why we should say we do not know that what is the status, whether it is pending or disposed of. Why we will say that in case it has been disposed of, it is open to you to avail the remedies under law. Why? Yes, next.
No, we have mainly said that because nothing is known, that is why not inclined to interfere. If there is some result, you challenge. There is no problem.
One line be mentioned.
No, one line
yes, next.
Item 16.
No, 16. No contempt. No contempt can die. Can you see page 12?
Which order has been flouted, Mr.
There is no order at all.
Order nahi? Contempt kaun hala?
Your lordship, contempt be again page 20 your lordship.
Just a minute. 20.
Page 12 first. There is no order.
Which is the order passed in this? Annexure 1.
Annexure 1. Annexure 1, page 12, paragraph 6 is the relevant portion.
Annexure 1, page number?
Disposed of in accordance with law, sir.
Is not inclined to grant any other such direction of this case. Till then, they have filed
to file an application. Page number 12.
Page number 12, paragraph 6.
Paragraph 6. Liberty is granted to the petitioner to file an application before so and so for early disposal of this one. Order.
Contempt is not made out. So now disposal pursue karive.
And contempt again that has been complied. Still then they have filed a second contempt.
Contempt
page 20.
Page 30.
20.
20.
Paragraph 2. It is admitted at the bar that this court's order dated 17/5/2023, violation of which has been alleged in the present contempt petition, has been complied with the passing of the order by the Special Land Acquisition Officer. It goes without saying that in case the petitioner feels aggrieved by the decision of opinion number 2, the petition shall be at liberty to question the correctness of the same before the application.
Say order which we are telling has already been passed.
First of all, there is no direction to maintain this contempt application.
ସେ order ଟା challenge କରିବନି
Madam,
ସେ order ଟା ଯୋଉଟା pass ହେଇଛି ସେଟା challenge କରିବେ ନା ସେଟା ବି ଆପଣଙ୍କୁ ଦିଆ ହେଇଛି liberty also to challenge
second
abuse of
contempt.
process ସେଟା ପୁରା abuse of process first of the ସେଟା the representation blind
Who
disposal
has
of-
stated, made a submission on that day on 9/4/2024 when the first contempt application was disposed of, that the order has been complied with?
By this state government.
That is not
It
written.
has been written admitted at the bar.
It is admitted at the bar. State Council submission lekha hai nahi. But if it has not been complied with and such a submission was made, then you should have taken time to verify whether it has been complied with or not.
ask
Therefore,
of this order
And there is no such direction as such.
Whatever it may be, so if it has been made a submission, what he says that it was made on the basis of the submission made by the Land and Additional Government Advocate who was present on that day.
Madam.
Of course, it has not been written. And if you find that in fact that has not been done,
Madam.
so you are supposed to file an interim application to recall the order because of a wrong submission which has been made in before the court.
Therefore, I
because
filed a
something
second
similar order
this contempt application. Liberty also granted to file an the second contempt. Your lordship, your lordship kindly say the running page 24, your lordship.
Con 24 con achi? Yeah.
Paragraph 1, 2, 3, 4, my lord.
Hmm.
The claim of the petitioner is genuine and the petitioner is entitled for the higher compensation under section 28A of the Land Acquisition Act
so that is correct.
as per the judgment of the area. But
No, we are doubtful about this order.
Madam.
You see the date of order.
my lord,
26 बोले लगा है
Date of order is 6/4/26.
6 4 26.
It has not come. We are in 2024. How can you file 2025? How can you file a order of 2026?
সেটা 24 লেগে সেটা
ମୁଁ
24
ଜାଣିନି,
আছে।
ଆପଣ file
ଲେଖିଛି
କରିବେ।
କିଏ
ମାନେ ରନି ପେଜ 22 ରନି ପେଜ 22 ରେ ସେ 24 ଅଛି
ଆପଣ ଦେଇଛନ୍ତି ଡେଟେଡ୍ ହଉଛି 6/4/2026.
ସେଟା ରନି ପେଜ 22 ରେ ଅଛି ସେଟା ଭୁଲ ସେ ଲେଖି ଦେଇଛି ତାଙ୍କରି ଆଜ୍ଞା ଗଭର୍ଣ୍ଣମେଣ୍ଟ
ତଳେ ଲେଖା ହେଇଛି 24
ଆଜ୍ଞା ରନି ପେଜ 22 ରେ ବି 6/4/2024
ହୁଁ।
ସାଇନ୍ ବି କରିଛନ୍ତି 6/4/2024
କଣ ହେଲା ତା ଦେହରେ କଣ କହିବେ?
ସେଟା ଏପର୍ଯ୍ୟନ୍ତ କିଛି କମ୍ପ୍ଲାଏ କରିନା ମାନେ କହୁଛନ୍ତି ଜେନୁଇନ୍ ଏପର୍ଯ୍ୟନ୍ତ ପେମେଣ୍ଟ କମ୍ପେନସେସନ ଦେଇନାହାନ୍ତି admitted that.
Bishop, I'll again reiterate the paragraph 6. There is no such direction to any of the authority.
No, is it? Do you mean to say that this page number 24 is a fake
That is-
document?
Your Worship, that is the instruction to the Advocate General Office that cannot be utilized in court.
That produced before the court, your lordship. Produced before the court.
Direction to the authorities.
dispose of ହେଇଗଲା writ petition what was the order
Hmm.
Worship, may kindly
dispose of so what is the contempt
Worship, may kindly see paragraph 6 of the writ petition. Your Worship. What they have written. The contempt
What
application.
if this order has been passed and the order has been complied with? So why have you approached again this court for second contempt?
That the same document has produced before the court in course of disposal of the contempt application.
Yes.
But the same order has not yet been. ସେ କହୁଛନ୍ତି ଆମେ dispose କରିଦେଇଛୁ
dispose of କରି comply କଲେ writ petition order so no contempt is made out
may liberty to file it.
no liberty is required you can file for ଅନ୍ୟ କଣ କରିବେ ଆମେ advice ବି ଦେଇପାରିବା
Yes, sir.
first
The,
contempt second contempt କରିକି ଏଠି
This is the second contempt petition filed by the petitioner.
totally misconceived
It appears that the petitioner filed WPC number 15422 of 2023. which was disposed of on 17/5/2023 with the following observation. Paragraph number 6 ta quote kar दें. The petitioner filed the first contempt petition in CONTC number 758 of 2024, and by order dated 9/4/2024, the same was disposed of. Since a submission was made at the bar that the order dated 17/5/2023 passed in WPC number 15422 of 2023 has been complied with by passing an order by the Special Land Acquisition Officer to Lower Indra Irrigation Project, Khariyar. The Land Council for the petitioner has also annexed the said order, which is dated 6/4/2024, wherein passed by Special Land Acquisition Officer and RRO on page 24, wherein it is mentioned that the claim of the petitioner is genuine and the petitioner is entitled for higher compensation under section 28A of the LA Act 1894 as per the judgment of the Land Senior Civil Judge Noapada in LAR number 30 of 2007. Therefore, the order which has been passed in 15422 of 2023 regarding early disposal of the petition under section 28A of this one has already been carried out. Therefore, there is no, this content petition is not maintainable according to disposed of. Yes.
Up to 19 you got.
17.
17, 18,
17,
19.
18, 19 the first round of contempt.
This is the first.
Huh.
And what is the order
There is
passed?
no direction
Same.
as such. Yes.
No, same you got.
Just
Second
just
round.
a minute. This is the first one. And similar order was passed.
Similar order.
So your instruction is that the decision has already been taken. So it is because this is the same order.
Yes, sir.
Yes, sir.
Similar kind of.
এই যেটা আপনারা দেখেন যে আরো কেসটার সেইয়া তো
Same you got. Running page 24.
running page 24 other we see like running here I was first contempt the petitioner wants to file the writ petition in WPC number 1412 in which the following order was passed. Paragraph number 6 for the Land Council for the petitioner has referred to a document which is dated Swansea, passed by Swansea, in which সেটা কোন এই কেসটাকে भी কনসিডার করেছেন জি
Same LR case.
এলআর কেস গোটিয়ে তো
Good year.
দেখে ইয়াদের এলআর কেস নম্বরটা কেতে
LR case number. 184 of 2010.
তাহলে সেম কিন্তু বুঝবেন
There are different person, different NRC.
তাহলে আদের ডিসপোজ অফ হিজ বলি আপনি কেমতি কইলে
The
same kind
same
of-
running page 24.
running page 24
Yes, sir.
just a minute we are in item number 195 to her concern
95.
195 এই যে অর্ডারটা তারপরে কোন হেলাও
The running page 24 যে খালি লেখেলে যে the claim of the petitioner is genuine and the petitioner is entitled for higher compensation.
ও সেই টাইপের তো অর্ডার পাস হইছে
সেই type right.
ও এই তো সিমিলার অর্ডার তাও করবেন
Similar.
yes
Up to 19 seconds.
Up to 19, sir.
next content petitions of disposal of
Number 20.
May last occasion you lordship had this matter about the restoration of the case, my lord. In this case, my lord, your lordship had this matter and issue notice to the opposite party, my lord. In the meantime, my lord, Warren Senior is appear and I file an objection, my lord. In 1 week time, I file a reply, my lord.
What is the delay?
Delay, my lord, 979 days.
Oh, 970. Where is your objection?
I filed yesterday.
Oh, yesterday.
It was in the list I was saying.
All right, IN number 147 of 2022. There is an application for condonation of delay. The Land Council, appearing for the opposite parties, submits that he has already filed the objection to this delay condonation application yesterday. Copy has been served on the Land Council for the petitioner.
Already served.
Who submits that he intends to file a reply to that
Yes.
objection, put up this matter in the 26 tarikh as well. Put up this matter in the commencing from 24th February 2025. Reply, if any, be filed in the meantime, giving copy to the Land Council for the opposite party. The objection filed by the Land Council for the opposite party be placed on record. Yes.
Oh, bless.
Item number 21.
Please, Your Lordship. Since Mr. Das has joined in the state panel, mail, his power may be ignored.
Who has joined?
Mr. Dasman Nagmante.
Yeah. He joined for it.
Manmohan Dasman.
Manmohan Kumar. Yes. But what is this amendment application?
Formal amendment during pendency. Kindly see the last order.
Is an application for inserting some paragraphs in the dispensary law. Copy of the interim application has been served on the Land Council for the Union of India. Summit doesn't want to file any objection to the interim application. However, Land Council for the state appearing for so submit their matter may be taken up next week so that you can go through the interim application. Submit the appearance payment has been allowed to continue file. Yes, what do you say? Union of India has nothing to say. They have no objection. Now it is only you who are the opposite parties number 3, 4, 5, and 6.
When it is concerned, we got the copy. So when the last order is concerned, we have not received any answer because file was missing. We have reconstituted the files to them. Not sure.
Formal amendment.
No, he is not having the file.
We reconstituted the file. The IA file yesterday.
You want another copy of the IA?
No, we have received that.
You have received. To go through it and tell because
the amendment is concerned, I have seen that.
Any objection? No. Look on IA number.
Petition
in the IA, there is a typographical error. Schedule of before paragraph 18, after how?
Or before there, after how?
After 18A, 18B.
তাছাড়া বাকি যাহা রয়েছে এগুড়াকে ইনকর্পোরেট করিবে 11th line of the prayer portion, the word by was in the order of font.
Paragraph 18 কোন দিটা রইব
18A 18B হবে
A 18B
18টা আছে তারপরে এটা এই দুইটা জায়গা হবে
এই মানে যে মাইক্রোস্কোপিক এ হবে
কিন্তু 18 হাইফেন হয় না
Annexure 11 was last year. Annexure was there. After amendment, it goes to the annexure 12. It mentioned annexure 12.
এটা 1913 পর্যন্ত Mr. Counsel, your writ petition consists of 11 annexure. So how this annexure would be annexure 13?
We will file application for amendment.
ये କହିଦେଲେ objection ନାହିଁ ये କହିଦେଲେ objection ନାହିଁ ତ ଆମେ କହିଲୁ ବୋଧେ ଠିକ ସେ ଦେଖିନି କହୁଛନ୍ତି. What do? You withdraw this interim application, find a better. Because you cannot, if you will not correct it as item number annexure 12, you cannot incorporate in that. Whatever permission would be granted, that is just to be.
जो फाइल करियो से साइटेशन तार पार्टी रो नाटा देबे साइटेशन ता देबे.
And also this yes ये जो paragraph 18 A लिखुचन ना एटा 18 hyphen A करंतु
बड़ा एटे लिखिबे
एटा बड़ा एटा लिखिबे आ ये जो डिसीजन टा को लिखिचंती इन 18 B रे तार रेफरेंस देबे एवं एटा कैपिटल ये रे करिवे
रेफरेंस देबे जदी साइटेशन नाही ताले तार रिट पिटिशन नंबर की CWP नंबर जहा थिबो सेटा देबे डिस्क्रिप्शन टा.
ये जो जजमेंट लिखछन एटा कोठी का कोर्ट रे जजमेंट कर्नाटक हाई कोर्ट
केस नंबर टा देबे
सुप्रीम कोर्ट में
सुप्रीम कोर्ट
रिसेंट
तार साइटेशन थिबो
2125 ना 2125 why have you not given the citation
के तो INSC रा थिबो निश्चय.
all right IN number so and so the land this is an application for amendment the land council for the petitioner seeks permission to withdraw this interim application to file a better one after upper leg jantu it is your name is Mr. S.K. Ratho Mr. S.K. Ratho land council submit that since Mr. Manmoy Kumar Das is now in state panel his name may not be reflected in the cause list. Yes. Matter be listed immediately after the interim application, fresh interim application is filed. Amendment. Yes. Giving copy to the other side.
Item number 22. May please your lordship. In pursuant to direction of the lordship, my lord, the notice was filed, my lord. There's some defect in that notice, my lord. Your lordship, I may be permitted to remove those defects, my lord, by the
incomplete requisites filed.
Yes, ma'am.
You filed the complete requisites.
No, your lordship.
It has been pointed out by the registry that due to incomplete requisites filed, admission notice could not be issued to opposite party number 328. And one set of process fee not filed. Stop. The Land and Council for the petitioner submits that he will file the complete requisites and remove all other defects as has been pointed out by the registry. Within what period?
By Monday.
By Monday. Yes. By Monday. All right.
Oh, please.
Item number 23.
Sorry, madam, there is a mistake.
Item 23, my lord.
Inadvertently, lordship directed me to serve a copy of the writ petition. Writ appeal order is there, but I could not do it. My lord, this is my mistake.
And order and counsel for the respondent number 2.
And also issued the notice to the opposite party, individual opposite party. I do not know that has been
filed
done.
his Wakalatnama and is submitted. He has not. Who is appearing for respondent number 2?
Mr. Patnaik is appearing. I am along with Mr. Patnaik. And I have not, last time I have prayed for, I have not received a copy of the writ petition.
Right.
Because the writ petition was disposed of without issuing notice to the opposite party.
All right. No. Just you said that you have also instruction to appear for respondent number 1 and 3. Have you entered your appearance for the?
I have Wakalatnama with me.
Just file it.
I will appear.
Because time was taken on that day, 15/1/25. And Mr. Mishra, have you solved a copy
I will
of that?
collect, Lord. I was not the lawyer in REIT.
Okay,
So
sir.
that copy is not with me. I will collect and give it.
Uh-huh.
I was not a
Mr.
lawyer for the
Land
immediate
Senior
petition.
Advocate submits that he has yet to solve the copy of the petition on the Land Council for the respondent number 2. So we can give you time for 1 week or
I will not sit down.
1 week.
I am ready.
1 week time. No, that copy just give it.
Copy, yes, but within 2-3 days I will give it a copy. I will try. Told my clerk to collect it.
The Land Council for the respondent number 2 further submits that will take steps for making appearance for the respondent number 1 and 3 in the meantime. So if this is done, then it can come on 3rd March 2025.
I will not sit down.
10th March. At their we file counter also.
10th March.
Put up this matter.
This is a 2014 matter.
From 10th March 2020.
I will not sit down. Obliged.
Item number 24. On 24, we are giving a short compilation, my lords, of all the orders in these cases, which would be convenient for your lordship.
What you are challenging here?
My lords, here we are challenging the order of the ASO, and this we had succeeded here before this court. Thereafter, the state went up in appeal, and the Supreme Court has remitted the matter.
Where is that order?
That, my lords, is at flag X. Last time I had shown. I'm sorry, it was flag 10.
Okay.
And in this compilation also, I have given that order. If your lordship,
no, we have got that order. Just
that's flag 10. Your lordship may kindly
please place it so that you can.
My lord. Page 6. The order begins.
That is there.
Having heard the learned counsel for the parties, we are of the considered view that the judgment needs to be quashed and set aside for the simple reason that instead of deciding each case individually on its given fact, the High Court proceeded to club and decide all the matters by presuming the facts to be common/identical and framing a common question of law. As such, on this short ground alone, the judgment requires interference. We are of the considered view that each case had to be considered on its own merits. Whether the power exercised by the ASO under the provisions of Section 12 of the Orissa Survey and Settlement Act were exercised prior to the finalization of the record of rights or at a subsequent stage was not considered by the High Court. Also, as to whether the aggrieved parties had exhausted the remedies as provided under 12A or 15B of the said Act was also not considered by High Court. The High Court proceeded on the assumption that all the petitioners before the High Court had leases in their favor in relation to which no record of rights was required to be prepared in terms of Section 12 of the said Act. As such, on these grounds alone, without commenting on the merits of the issue and the contentions raised before us, we remand the matter to the High Court for consideration.
So what order we passed on the last date?
On last date, in the first matter, your lordship directed us to give us the appeal number. So that manner we have applied the status and the appeal number. That instruction we are not yet received.
So that is the crux of the matter. If your appeal is pending, you are to and you have already availed the alternative remedy. It is to be considered and disposed of in accordance with law. So why we will entertain this writ petition at all?
If your lordship wants, I can show my lord why this writ, first writ matter.
No, you see the ASO order was challenged here directly, and simultaneously also you challenge it in appeal. That is 12A provision, and that is exactly the reason why we asked you to ascertain the appeal number, of course the status of that appeal, because in the writ petition you have stated that that was perhaps pending in that way.
Our instruction, my lord, is that of course we have applied now under the RTI. All such appeals across the board have been dismissed.
Then again, so if that is the stage, then the next stage would come. that
If your lordship sees the Supreme Court order,
what is your instruction, Mr. State Counsel?
may I just point out one point, one legal point there in our case.
About this factual aspect, we must see that it must be brought on record that what is the position of your appeal, what is the stage. If you say that this is the mine appeal number and this has been already dismissed, this was dismissed on that day, that is the
Then your
appeal.
lordship may give us 10 days, we'll try to get
just file an affidavit or in something like that.
My lord may grant me 10 days.
अरे सेटा ना कन्फर्मेशन आसिले जे आपण अपीलटा डिस्पोज ऑफ करि साइलेनी एई नंबर अपील ऑर्डरटा को कम्युनिकेट कलेनी बा जहां भी हो एक जानि साइला परे सिना नेक्स्ट रिकोर्स को जिवे तो सेही जिनसडा से कहउछंती जे तांको आरटीआई रे मागिथिले आरटीआई इंफॉर्मेशन आछि जे अपील हैज बीन already disposed of.
RTI application they have filed. They have not yet got that concrete information. He's saying that all such appeals have been dismissed, but that application, concrete information, I have not got. So your lordship may give me 10 days. We'll try to get that exact. What is the date and what is the date?
Look on the Mr. Both Minister and Senior Advocate appearing for the petitioner submits that so more time is required to obtain the concrete information relating to the status of the appeal, which has been preferred before the authority challenging the order dated 31/5/2013 in objection case number 16409 of 2013 passed by the opposite party number 2, Assistant Settlement Officer for the camp at Bhubaneswar. Matter be listed. So today is, can it be done on 24th or you want some more time?
Some more time.
Let it be then on 3rd of March, then this matter on 3rd of March 2025. Yeah.
How about the WPC number 2021?
Just one by one we'll go. This is 3rd March 2025. Yes. Next item is WPC 2798 of 2014. Mr. Sanjay Kumar Samantroy.
Yes.
Please come. So, what is your prayer in the writ petition? You are challenging what?
Challenging the appeal order passed in
Annexure 6.
Yes, my lord. 2172 of 2013. That record has not been received.
Just a minute. Please come to that order. Let us place it there also.
Well, 5/10/2013.
Yes,
it is put up today. Applicant present on call had him perused the omens report on status of land status and verified the documents submitted by him, including the copy of lease quota, Jamanbadi register and RST, which from a part of a case record. The suit land bearing suit Sabik Khata number so and so, plot number 25 so and so, bearing a leasehold lease record in Khata number 805 of recorded in the name of Sri Subhash Chandra Samantray in Dakhal Satya Sunya status. The lease principles are followed and cannot be are followed or cannot be confirmed due to non-availability of
documentary evidence, yes.
Whether the lease is confirmed or correct. Whether the lease has been reviewed by the committee as per order of Honorable High Court in urgency number so dated 29/1/96 is known to this office. The appellant also cannot submit the lease
deity, including
lease deed, including
so and so.
trace map of the leased out land.
Yes.
In view of this above, the Tahsildar, the authorized officer, may take steps for redress of a grievance of the petitioner as per order of Honorable High Court. For ASO do not have such authority.
So now that order has been set aside.
Thereafter, the appeal was dropped. The appellant is advised to advise the Tahsildar Bhubaneswar for redressal of his claim or may approach the other forum. Now here what happened, the lease was initially granted, more a note of submission are there, more written note of submission. Lease was granted in favor of Panu Naik.
No.
Yes.
This A by C number, what is this A by C number? जोड़ा लिखा है जी annexure 6 रे.
Yes, ma'am. A by C माने appeal case number.
Appeal case number.
Yes,
so against which order you approach the appellate authority?
Well, because at the time of Khanapuri operation, the petitioner being a bona fide purchaser, he submitted all the documents before the
who order against a appellate authority to approach କରିଥିଲେ प्रश्न simple.
ତାଙ୍କର ନାଁଟା ଯେତେବେଳେ ସେ ଜାଣିଲେ ଯେ ବର୍ତ୍ତମାନ ଯେତେ ସବୁ ଆଦାସ୍ତ ଇସ୍ୟୁ ହେଇଛି ପାର୍ଚା ଇସ୍ୟୁ ହେଇଛି ପାର୍ଚା ମାନେ ନଟ୍ ଫାଇନାଲ ଆର୍ ଇସ୍ୟୁଡ୍ ଅଣ୍ଡର ସେକ୍ସନ 12. So up to section 12 ମାନେ everything is okay in favor of the petitioner being a bona fide purchaser. During the Khanapuri operation, the entire land was acquired by the ASO, self authority ASO, and it was held that the petitioner being bona fide
this order which was passed in the operative part, it is stated that the Tahsildar as the authorized officer may take steps for redressal of the grievance of the petitioner as per the order of the High Court. So ASO and SO do not have the such authority to restore that so and so. So which is the order he is referring to? That the Tahsildar is empowered to adjudicate the matter.
Paragraph 9 of my lead petition.
Yes.
After purchasing, the petitioner mutated the land in his favor by the revenue authority, and thereafter he got the adjust during the current settlement operation. And under section 12, the Parcha not final ROR was also issued under annexure 5 in his favor. But paragraph 9, that in the aforesaid faction circular, it is most relevant to mention here that when the rent camp started under section 18, in the said Moja Andhadwa,
you are not following up the what we are asking you that the appellate authority has dropped the appeal with observing that in view of the order passed, he cannot have the authority. He is not having the authority. So which is that order passed by this for which he says so and drop the appeal? That is the exact query which we want to make you making it.
May I just assist your lordship?
Yeah.
Regarding that order which was of the Honorable High Court.
Yeah.
that is reported judgment 81, that is the PIL matter. The PIL was filed, that is presiding judge, my Lord Justice D.P. Mahathir was there. In that PIL, there was a allegation, mass allegation, that lease has been given, my Lord, without properly examining to even ineligible person, post land lease case.
Okay.
So that is why the Honorable Court directed that the leases which have been given, that should be reviewed.
Okay.
That should be reviewed. That means case to case, that was reviewed. So
in your case, what happened?
Whether the ADM has revived or Tahsildar.
No, here no revision has been made. But after 30 years, he has sold. So review is a limited matter. Under OGLS Act, within 14 years, the revisional power is there. After expiry of 14 years, revisional power is not extended.
No, perhaps these are the cases where that goes to the root of the matter. The allegation is that fraud has been committed. This procedure which has led down before grant of lease, that has not been followed, and these are all so that is the reason perhaps
number of cases, well, there has been division and also resumption under section 3B, and they are the authorities ADM and Tahsildar, they are the authorities under the OGLS.
Yeah.
So many cases there has been division and that has come to this Honorable Court, number of cases, and this Honorable Court has set aside the orders that there has been no proper examination. My Lord, it may be a case that here they did not think it proper, that may be properly done. That is why there has been no revision. So, my Lord, these are cases will be coming up before your Lord. So, after that, the ASO being the authority within the purview of the Orissa Survey and Settlement Act has no authority to act as the OGLS authority. That is also the division bench judgment.
No, we are not going general. We are going to individual. In this case,
individually, your Lordship can receive after obtaining the pacha under section 18 and paragraph 19, 9, I have stated as per rule 51 and under section 18 and 19, chapter 4, the settlement authority has only to fix the rent if there is no objection.
Mr.
But
Counsel,
here
you are answering.
But
the appeal has been disposed of with an observation that you are to approach the Tahsildar Bhubaneswar for the redressal of your claim.
Yes, my lord.
You have not approached the Tahsildar. You have come directly to this court.
Because Tahsildar has no jurisdiction under service settlement. I am affected by the service settlement order, my lord. So Tahsildar has no jurisdiction. So Tahsildar seized under section 54, my lord. Tahsildar has jurisdiction after publication of ROR. Final publication of ROR.
Let us go to see that which order you are challenged before the
order here, my lord, the ASO so moto.
Which order you challenged before the appellate authority?
Because ASO reviewed so moto the not final ROR issued in favor of the petitioner. I have stated in paragraph 9, my lord. Against that, my lord, I prefer the appeal. But the appellate authority neither called for that under what case, rent objection case, and what so moto. Without calling that, he has dropped the appeal. Paragraph 9, I have categorically stated, after getting the pacha, my lord, it was only, paragraph 9, I am permitted to place, that in the aforesaid factions, it is most relevant to mention that when the rent camp started in the Mojar on the Rua, the assistant settlement officer was only to fix the fair and equitable rent in respect of the scheduled land as per statutory provision under Rule 51 of Orissa Survey Settlement Rules 1962, read with mandatory provision under section 18 and 19 of chapter 4 of the Orissa Survey Settlement Act, for which the petitioner also produced all the relevant records, but thereafter came to know from the reliable source the assistant settlement officer without doing so and without fixing any fair and equitable rent as per purchase issued in favor of the petitioner and also without complying the previous order directed to record the scheduled land in favor of the state government and also complying his previous order directed to record the scheduled land in favor of the state government as abajogya anabadi khata. But in spite of steps taken by the petitioner, neither the copy of said order
the observation which has been made in that order that you are claiming that your name be reflected in the ROR on basing on the that grant of lease.
Yes, my lord.
So where is the document?
Document, my lord, annexure 1.
What is that?
Annexure 1 is the sale deed.
No, not sale deed.
My lord, I am not annexed, but here the ROR.
You are Mr. You are Subhash Chandra Samantray.
Yes.
Who is dead now? The legal heirs have been substituted.
Yes,
so, how this Subhash Naik came into picture here? One Brajabandhu Naik has sold the land to Udi Naik.
My lord, paragraph 3 to I have started.
How
first of all, Panu Naik was a lessee. The land was allotted in his favor for homestead purpose, and after 30 years, he sold to the Bhaji Naik.
तो गोटे आपण जो रजिस्टर्ड सेल डीड टाको बर्तमान बेसिस करछंती ना से रजिस्टर्ड सेल डीड रे लिखा है ब्रजबंधु नायक बिकिला उदी नायक को तो ये पिटिशनर रो नाम होची
ये
सुभाष चंद्र सामंतराय
यस ये होची फोर्थ परचेजर मानर
हां
पाणु नायक फास्ट बिकिला भाजी नायक
ये लोक काटू आनिला ये जो जमीटा जो कहूची ता नारे रजिस्टर हबो बोली को कबला काई सुभाष चंद्र सामंतराय को किए दे से जमी देला
ब्रजबंधु नायक
काई से कबला
होची ब्रजबंधु नायक होची अनेश्वर
1 पूरा कोल देखिले आपण क्रेता होउछिन उदी नायक बोली
हां नहीं ब्रजबंधु नायक से बिकिले उदी नायक
हां
उदी नायक बिकिला सुभाष चंद्र नायक
मु आपण कोन पचारती आपण कोन आंसर दोउछंती सुभाष चंद्र सामंतराय विथ द रिट पिटिशनर हाउ ही is claiming that the property belongs to him on the basis of what document?
My lord, document means he has already Subhash Chandra Samantraye mutated कर दी ता लैंड पर किनिला पर
मु सेंडी चंद्र सामंतराय आपण जो रिट पिटिशनर केमिति पाइला से लैंड काहाटू किनिला
से
डॉक्यूमेंट काई
the Bhaji Naik
have you annexed those documents?
डॉक्यूमेंट annexure करनी किंतु मेंशन करछि
मेंशन आपको करते
डिटेल देई चंदी रजिस्टर
पैराग्राफ 5
देई चंदी
पैराग्राफ 5 में
सेटा ताले कोंतु जोटा पछ
the Bhaji Naik as belongs to the scheduled caste category paragraph 5 of my report
भजी नायक विषय माने पैराग्राफ 4
पैराग्राफ 4 रे भजी नायक किनिला
तोरा सेठो स्टार्ट तापर जीव सेठो
हां ना ये किनि चंदी भजी नायक
ना ता पूर्वरु आ कोन हेति ना
हां ता पूर्व
पाणु मरि गले ब्रजबंधु नायक रहि
नहीं पाणु एक्सपायर कला परे तार होसी
मतलब से कहू जे अपन पिटिशन पढ़ी के से कहू जे अपन ना कहू जंदी who being inherited the said land अच्छा
भजी नायक से शेड्यूल कास्ट परमिशन नै छु ओला रे
सेटा कोठी
ओला 22 पैराग्राफ
5 इलेक्शन भजी नायक तो अच्छा he sold to
Bhaji Naik being a bona fide purchaser also was in peaceful possession of the scheduled land.
Paragraph 3 टा actually अपन begin करछंती जे तहसीलदार भुवनेश्वर WL लीज केस नंबर 619 of 1959-16 रे को देले पानु नायक
yes madam
हला for homestead purpose
yes madam
right तापरे पानु नायक के किनला
ना को
पानु नाहक
ପାଣୁ ନାୟକଠୁ କିଏ କିଣିଲା?
ପାଣୁ
He
ମରିଗଲା
died. ସେ expired କରିଗଲା। ତା ପୁଅ କିଏ? ତା ବ୍ରଜବନ୍ଧୁ ନାୟକ। ସେ after 30 years ସେ ବିକିଲେ ଭାଜୁ ନାୟକ।
ଭାଜି ନାୟକ ହେଲେ शेड्यूल कास्ट
ଇଏ ବି scheduled caste।
କିଏ?
ଭାଜୁ ନାୟକ।
अरे ये बी तो ହେଲା ଅସୁବିଧା ସो ପାଣୁ ନାୟକ
ପାଣୁ ନାୟକ scheduled caste, ଇଏ ବି scheduled
ତ
caste।
ସେତେବେଳେ ପରମିଶନ ଦରକାର ହେଲାନି
ନାଇଁ,
ବଟ ଯେତେବେଳେ
ଭାଜୁ ନାୟକ ଯେତେବେଳେ ବିକିଲେ ସେତେବେଳେ ପରମିଶନ ଦରକାର ହେଲା। ସେ 22 ରେ ପରମିଶନ ନେଇକି in favor of a petitioner ଭାଇ
ସେଟା କିଛି ପରମିଶନ ଦେଇଛନ୍ତି। ଆଚ୍ଛା
ପରମିଶନ ନେଇକି ତାକୁ ସେଲ୍ ଡିଡ୍ 1992 ରେ ସେ ବିକିଲେ।
ତାରି ପରେ ଏ କେସ୍ ରିଭାଇଭ ହେଇଛି ଏଠି ହାଇକୋର୍ଟ ରେ। ଏ ଯୋଉ ଧରା ପଡିଲା ଯେ ଏଇ ଟାଇପ ର ଯେମିତି ଆସିଲା ଯେ ଏସବୁ ଲିଜ୍ ଯେମିତି without following the due procedure lease has been granted.
Yes, ma'am. But this case not revived.
Mr. Samantra, 1 minute. Annexure 2 କହିଲା copy of the permission. Annexure 2 ଟା ଟିକେ ଦେଖିଲେ ସେଟା permission ନା application? ନା ଏଟା permission ଟା?
Yes, permission ଟା।
କୋଉଠି ରହିଲା permission of the revenue officer? ଠିକ ଅଛି। କୋଉଠି ଲେଖା ହେଲା?
ସେଟା revenue officer ତାଙ୍କର permission ଦେଇଛନ୍ତି।
Purpose of transfer purchase
under section 22(1)(b) of OLR Act.
Reasons for as no SC/ST person is willing to purchase. ହଉ ତାପରେ
ସେ କିଣିକି ମାନେ ସେ ପିଟିସନ ଅଲରେଡି ମ୍ୟୁଟେସନ ବି କରିଦେଇଛି ତା ନାଁରେ under annexure 3
petitioner କିଣିଲା ପୁଞ୍ଜି ନାୟକରୁ।
ହଁ, annexure 3 ରେ ସେ ମ୍ୟୁଟେସନ କଲା।
ସେ ମ୍ୟୁଟେସନ ଟା କାଇଁ ବାରମ୍ବାର କହୁଛନ୍ତି? ଆମେ ଜିନିଓଲୋଜି ଟା ଫଲୋ କରୁଛୁ କେମିତି ଫ୍ଲୋ ହେଲା ଟାଇଟଲ।
ତାପରେ ROR ଇସ୍ୟୁ ହେଇଗଲା ଏ ଯୋଉ ସୁଭାଷ ସାମନ୍ତରାୟ ନାଁରେ।
Yes, madam.
ତାପରେ ଆପଣ ରେଣ୍ଟ ଦେଇକି ଚାଲିଲେ।
ରେଣ୍ଟ ଦେଇକି up to 2013 ପର୍ଯ୍ୟନ୍ତ ରେଣ୍ଟ ବି ଦେଇଛି।
ତାପରେ କଣ ହେଲା?
ତାପରେ during current settlement operation section 12 ରେ ମତେ not final ROR ପାଚା ବି ମିଳିଲା under annexure 5। ସେଟା ଖାନାପୁରୀ ଅପରେସନ ଫିଲ୍ଡ ଇନକ୍ୱାରି ହେଇ ପଜେସନ ହୋଲ୍ଡ କରି ଫ୍ଲୋ ଅଫ ଟାଇଟଲ ହୋଲ୍ଡ କରିକି ଏସଓ ଦେଲେ।
କ୍ୟାନସଲ କେବେ ହେଇଛି?
ମାନେ
କ୍ୟାନସଲ ଟା କେବେ ହେଇଛି?
ତାପରେ ଏଇ ୟାରି ଉପରେ ଯେତେବେଳେ
ଡେଟ୍ ଟା କହିଦେଲେ
ଡେଟ୍ ଟା ବି ଆମେ ଜାଣିନୁ। because that is so motor behind the petitioner.
ସୁ ମୋଟୋ ହେଲେ ବି ତ ଗୋଟେ ଡେଟ୍ ଥିବ।
ସେଇଟା ଅପିଲରେ ସେ ମାଗିବା କଥା ନା, ଅପିଲରେ ସେଇଟା ମଗା ହେଇନି।
ନାଇଁ, ଆପଣ ତ ଏଇଟା କହୁଛନ୍ତି ରେଣ୍ଟ ଦେଇକି ଚାଲିଲେ 2013 ରେ। ତାପରେ କଣ ହେଲା ଆପଣଙ୍କୁ?
ତାପରେ ପାଚା ମିଳିଲା। ସେଇ ଏଇ ପାଚା ଏଗେନ୍ଷ୍ଟରେ ସେ ତାକୁ ରିଭ୍ୟୁ କରିଦେଲେ, ପୁଣି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଖାତାକୁ ଇଏ କଲେ। ସେ ଅର୍ଡର ମୋ ପାଖେ ନାହିଁ। ସେଟା ଆମେ ଯେତେବେଳେ ଚେଷ୍ଟା କଲୁ ବି ପାଇଲୁନି। ତା ଏଗେନ୍ଷ୍ଟରେ ଆମେ ଅପିଲ କଲୁ। ସେ ଏଣ୍ଟାୟାର ଯେତେ ସବୁ ପାଚା ଇସ୍ୟୁ ହେଇଥିଲା ସବୁ ଯାକ ଅପିଲ ମେମୋଟା ଫାଇଲ କରିନାହିଁ।
You have not the copy of the appeal memo. You do not know which order you challenge before the appellate authority. And appellate authority said that drop the appeal and advised you to approach the Tahsildar. So what is the illegality committed?
Actually, after the issue of Pacha, petitioner no way affected still issue of not final ROR in his favor. But when so much it was cancelled, in which case
that order learning council we are asking you that ଆପଣ କହୁଛନ୍ତି so much cancel ହେଇଗଲା, ସେ order କାହିଁ?
ସେ order ନାହିଁ ଆମ ପାଖରେ।
ଆଉ ତାହେଲେ ସେ order କାହିଁ? ଆପଣଙ୍କର ଅପିଲ ଯୋଉ କଲେ କଣ ଗ୍ରାଉଣ୍ଡ ତାର ଅପିଲ ମେମୋ କାହିଁ? ତାପରେ order ଟା ପାସ୍ ହେଇଗଲା 2013 ରେ। ସେ ଅପିଲ ଟାକୁ ଡ୍ରପ କରିଦେଲା ଯୋଉ ଏଗେନ୍ଷ୍ଟ ରେ ଆପଣ ଆସିଛନ୍ତି ଏଠିକି। କହିଦେଲେ you are advised by the to approach the Tahsildar Bhubaneswar for the redressal of the grievance.
ସବୁ କେସ୍ ମତେ ଆଦାୟ କରି କଲେକ୍ସନ କରିବାକୁ ପଡିବ।
counter affidavit file ହେଇଛି ନା ନାଇଁ?
Counter affidavit not filed. 2014 ମସିହା କେସ୍ 2024 ପର୍ଯ୍ୟନ୍ତ କାଉଣ୍ଟର ଆଫିଡେଭିଟ୍ ଫାଇଲ ହେଲାନି, ରେକର୍ଡ ବି ଆସିଲାନି।
ମଗା ହେଇଥିଲା?
All cases are assembling ପୁରା ଏଣ୍ଟାର ସାଇକଲ ଷ୍ଟାଇଲ ଅର୍ଡର ହେଇଛି ଏଣ୍ଟାର ଭୁବନେଶ୍ୱର।
ନାଇଁ ବର୍ତ୍ତମାନ ଆମେ ସେ ସାଇକ୍ଲୋ ଷ୍ଟାଇଲ ଆଉ କରିବୁନି, ଆମେ ଇଣ୍ଡିଭିଜୁଆଲ କେସ୍ କୁ ଯିବୁ। ସାଇକ୍ଲୋ ଷ୍ଟାଇଲ ଅର୍ଡର ହେଇଥିଲା ବୋଲି ସେଠୁ ସେଟା ସେଟ୍ ହେଇକି ଆସିଲା ଇଣ୍ଡିଭିଜୁଆଲ। ଏ କେସ୍ ର କିଛି ନାହିଁ, we are dismissing this writ petition.
highly collected appeal.
Yes, when notice was issued in the year 2014, they had been asked to file counter also, as well as
Yes, Mr. State Counsel, the first order was passed on 19/2/2014, and you were asked to produce the records, and then status quo order was passed. So then you are not having any record with you now.
Have the records ever been called for?
Counter affidavit, if any, be filed in the meantime. सेटा सेथिपाई आपनको 6 सप्ताह समय दिया हैतला 19/2/2014 रे। तेणु 9 वर्ष परे से केस बोधे जाइए डिस्पोज ऑफ हला।
Directed each case individually. So counter affidavit
is necessary, my lord, for that reason. So I pray, my lord, as this is the earlier that case was listed on 2014, and thereafter case was listed on 2023. In the meantime, there is no counter, neither, and after disposal of the petition, the file was also reconsidered because
yes, it goes off to that other building.
So
चिट्ठी कौन जाइथियो कौन also you don't know.
that this is a very new file.
This writ petition has been filed by the petitioner.
If you try मिली परिवा थाकरे थिबो.
Subhash Chandra Samantway.
Again, may record me call for so that you can call that only.
With a prayer to was the ex parte order dated 5/10/2020.
Scan ही कितनी वो देखो. 2023 यदि scan ही कितनी वो आपको कंप्यूटर में देखो.
Passed by additional sub-collector Bhubaneswar in appeal case number 2172 of 2013, wherein it was held that you had the while dropping the appeal, the petitioner was advised to approach the Tahsildar Bhubaneswar for redressal of his claims, or may approach any other court. The Land Counsel for the petitioner submitted referring to paragraphs number 3, 4, and 5 as to how the petitioner for the land by way of a sell deed. The Land Council submits that after the physical possession was taken over by the petitioner, the land was also mutated in the name of the petitioner in mutation case number 8380 of 1992. And the petitioner constructed a pakka house in that land, and he was paying rent for the land up to 2013, and the rent receipt has been annexed to this writ petition as Annexure 4. It is the contention of the Land Council for the petitioner that a field inquiry was conducted by the Assistant Settlement Officer, and the parcha was issued in favor of the petitioner via Annexure 5. And thereafter, the petitioner came to know from the reliable sources that without fixing any fair and equitable rent as per the parcha issued in his favor, the land was recorded in favor of the state government as Abad Jugya Anavadi Khata, for which he preferred the appeal by appeal case number 2172 of 2013 before the additional sub-collector cum additional settlement officer, who passed the order under Annexure 6, which is impugned in this writ petition. When we made a query to the Land Council for the petitioner, as to whether he is having that order in which the Assistant Settlement Officer directed the land to be recorded in favor of the state government as Abadugyo on Avadi Khata, and whether he is having the copy of the appeal memo with him, the answer was a negative. However, the Land Council for the petitioner took some time to obtain instruction regarding the availability of such document and to produce the same on the next date. Subpara. In this case, while issuing notice on 19 to 2014, the Land Council for the state was directed to file the counter affidavit within 6 weeks, and for the direction was issued to call for the records, and status quo order was passed in respect of the possession of the case land. with further order that no coercive action shall be taken against the petitioner. The Land Council for the state submits that no counter affidavit has been filed in this case, and the records of the case is also not available with him.
In view of the disposal of the case,
In view of the disposal, ये जो so दुई एक case order
पेन ड्राइव रे हाईकोर्ट रो गोटे नहीं जानतु सेटा अछि पेन ड्राइव रे you can take a copy of the petition and
you have to reconstitute the file. You take the pen drive. The Land Council
authorities will get those
to
instructions. What if they have given you, they will send.
The Land Council for the state submits that the file is to be reconstituted, and the registry may be asked to supply the copy of the writ petition and the orders passed in this case. So also the copy of the miscase and the interim applications. And the written note of submission filed by the petitioner. Let the same be registry supply the same to the Land Council for the state on the pen drive, and the Land Council for the state after receipt of the documents shall obtain necessary instruction and comply the order dated 19/2/2014 and file the counter affidavit within a period of 4 weeks. Within a period of 4 weeks, matter will be listed. April the interim order dated 19/2014 passed in miscase number 2717 of 2014 shall continue till next date.
But you save your lordship's precious time, my lord. May I intervene? My lord, in this case, I'm there in sub-item number 31 and 32. But in my cases also, no counter has been filed, and most of the cases, no counter has been
Since it has been asked to us to go each case, so these matters will be listed tomorrow again.
Yes, sir.
So we'll go serially.
File counter, because in most of the cases,
No.
We have to pass that order.
After looking into not that in that way, we'll go individual case. Huh? So tomorrow from this other matters will be listed like that. Huh? 2799 to ଯେତିକି ଅଛି ସେଟା ଆପଣ take up କରିବେ.
2799 my lord. The petitioner already taken the file to
କଣ କହୁଛନ୍ତି?
ମାଇନସ୍ ଟା କେବେଠୁ ଅଛି ମାଇନସ୍ ଟା ଲିଷ୍ଟ କାଇଁ କରୁନାହାନ୍ତି ମାଇନସ୍ ଟା ତ ଅଛି 6/1 ରୁ 6/2 ରୁ ସେ ମାଇନସ୍ ହେଲା କଣ ହେଇଥିଲେ ମାଇନସ୍ ହେଲାଣି
ଏଇଟା କଣଟା ଆପଣ ଦେଇଛନ୍ତି ଏଇଟା ସିଆରଏଲ କଣ
ସେଟା ଯୋଉ ମାଗିଲାନି ଇଣ୍ଟରିମ୍ ବେଲ୍
ହଠାତ୍ କହିଦେଉଛନ୍ତି ମୁଁ କହୁଛି ମୁଁ ଭାବିଲି ରିଟ୍ ପିଟିସନ ଅର୍ଡର ହେଇଛି ତ ଏଇଟା କଣ ପାଇଁ ଆମେ କହିଥିଲୁ ଏ ଯୋଉ ଡେଥ୍ ହେଇଯାଇଥିଲା
ସେଟା ନୋଟିସ୍ କାଇଁ କଲେନି ଆମେ ତ ଅର୍ଡର କରି ସେଇଠି ପଠେଇ ଦେଇଥାନ୍ତୁ କିଏ ସେଟା ଡିଆର୍ ସେ କିଏ କୋର୍ଟ ଡାଇରେକ୍ଟ କଲା
ଆମେ ଆପଣଙ୍କୁ କହିଲୁ ସ୍ପେଶାଲ ନୋଟିସ୍ କରିବାକୁ ଆପଣ ନୋଟିସ୍ କର
Next matter, Lordship, fix it on 24.
Hearing ପାଇଁ ଅଛି?
hearing.
Actually, we are taking of one hearing matter after all the matters are finished. So it may not reach. Hearing starts from item number 11.
No, Melody, if I get a copy of that, I will prepare.
Oh, you have not got the paper book?
It has come on transfer recently to me.
Item number
28.
28 ସୁନନ୍ଦା ବିଶ୍ୱାଳଙ୍କ ନାଁ ଅଛି?
ତାପରେ ମୋ ପାଖକୁ
ଆଚ୍ଛା, ଅର୍ଡର ହେଇଛି?
ହଁ, ଅର୍ଡର ହେଇଛି।
ଦେଖି।
A prisoner's petition has been received.
And my operation also.
Order not your.
Is engaged on sessions.
Third an order.
The last order, it was directed that Sunanda Vishwal is to be engaged. She has been engaged as the amicus curiae to argue the matter, and your good name is
Durga Prasad Sangal.
How you get into it? Durga Prasad to na to kebe nathila. Apon kemti asile?
How are you saying that order has been passed in your favor? There is no order.
I mentioned that is
Don't make wrong submissions. Others, aswida hai jo. Toda prisoner's petition le tang na achi.
No, business person le thila.
Acha. Prisoner's petition dated 30 AK. How many? It is at flag A.
ସୁନନ୍ଦା କୁ ମୋର ଓକିଲ ଭାବରେ ଚୟନ କରିଥିଲେ। ବର୍ତ୍ତମାନ ମୁଁ ନିଜସ୍ୱ ଖର୍ଚ୍ଚରେ ଆଚ୍ଛା ମାମଲାର ପରିଚାଳନା ପାଇଁ ଆଡଭୋକେଟ ଦୁର୍ଗା ପ୍ରସାଦ ଆଚ୍ଛା ସେଥିପାଇଁ ଆପଣ ଫାଇଲ କଲେ।
ସେ ଫାଇଲ କରିଦେଇଛନ୍ତି ବି वकालतनामा।
ହଁ ଠିକ ଅଛି।
But it has to be accepted.
ଆଚ୍ଛା ଏଇ ଆଇଟମ ନମ୍ବର 28 ରେ ଲେଖନ୍ତୁ। JCRL number 57 of 2021. As per order dated 2/1/2025, this court engaged Mrs. Sunanda Biswal, advocate as amicus curiae, to argue the appeal on behalf of the appellant. However, and it was further and it was intimated to the appellant, but the appellant has filed a prisoner's petition wherein he has stated that he wants to engage Mr. Durga Prasad Sangramjit Malik as his private counsel, and Mr. Malik has also filed Wakalatnama. The request made in the prisoner's petition is accepted, so also the Wakalatnama. The name of Mr. Durga Prasad S. Malik and his associates they reflected in the cause list henceforth. The name of Mr. Sunanda Biswal and PM Tarai. PM Tarai भी आपको counsel. Name of Sunanda Biswal shall not be reflected. Yes. And you want a paper book. Let a copy of the paper book be supplied to the Mr. Malik. अच्छी पेपर बुक जब काढ़ी देगी अपन टिके अपेक्षा करिए रिसीव करने नहीं तो add to the hearing list. It is already there, but you say add to the hearing list next week or the hearing list. Yes. No, that is not.
Supplemental list, item number 1.
Legal aid list again.
The list cause list.
Legal aid committee cause.
This appeal has been received from jail late by 116 days. For the generation. Delay condone admit call for the trial court record.
Nobody else is agreeing or what? अरे 2022 राव 23 राव है नी नेक्स्ट 7 ವರ್ಷಗಳ ಬಗ್ಗೆ ಮಲ್ಟಿಪಲ್
16 17
ಮಲ್ಟಿಪಲ್ ಬ್ರಾಂಚಸ್ ಇದೆ ಸೇटा खाली ಸ್ಪೆಸಿಫಿಕ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅರೆ ಮಲ್ಟಿಪಲ್
first hour is 302. Second hour data 302. No, it's not necessary that we should follow it. We are giving the names.
ಆರೋಪ ಮಾಡಿರೋ ಜೊತೆಲ್ಲ ಆರೋಪ ಆರೋಪ ನಂದದಾಸ್ ঠিক আছে
Yes. Well, come.
Item 3.
Prisoner's petition has come
Yes, my lord.
for engaging Saroj Kumar Rautray.
Yes, my lord.
You are Mr. Rautray.
Yes, my lord.
And have you filed your Vinama?
No, my lord, I have not filed. I am not yet filed, my lord.
Oh, filed. He has prayed for your engagement and so. Business petition.
Usually petition sign would have
purchase. अच्छा ये ଗୋଟେ वकालतनामा सेटा वकालतनामा बाहर करो हम से फिल अप कर दीजिए
फैम कौन लगे नहीं କରିକି ରେଜିଷ୍ଟର ଦେଇଦେବେ
ଆପଣ ଏଇ ଯୋଉ वकालतनामाରେ ସେ ପଠେଇଛି ତାକୁ ଷ୍ଟାମ୍ପ କରିବା ଲଗେଇକି ଫାଇଲ କରିଦିଅ ହେଲା
ଏଠି ଦିଆ ହେଲା ବୋଲି କହିଦବା ସେ ରେଜିଷ୍ଟର ଫାଇଲ କରିଦେବ
just a minute just pay you the prisoner's petition dated 12/1/2024 in which request has been made for engaging Mr. Saroj Kumar Rautray as the advocate in case of Mr. Ellen Patel. Prayer is accepted. Mr. Saroj Kumar Rautray is engaged as the counsel for the appellant. The client has sent a Vinama, signed Vinama with the prisoner's petition. Same is handed over to the learning Mr. Rautray.
handed over କରିବ କଲେ ରେଜିଷ୍ଟର କଲେ କରିବ ରେଜିଷ୍ଟର ଦବ କଣ କରିବ ପିଏ ଗୁଡା ସବୁ ବଢେଇ
सीता पूरा फिल अप कर
ନାଇଁ ନାଇଁ ରେଜିଷ୍ଟର ନେଇକି ତାଙ୍କୁ ସେଠି ଫାଇଲ କରିବ ନା କୋର୍ଟ
ଏଇଠି ଆମେ ତାକୁ ହ୍ୟାଣ୍ଡ ଓଭର କରିଦେଲେ ସେ ଫାଇଲ କରିବ ଆପଣ ଆଜି ଫାଇଲ କରିଦିଅନ୍ତୁ ଆମେ ଲେଖି ଦଉଛୁ ଆପଣ ଫାଇଲ କଲେ ବୋଲି ବଟ୍ ହଁ ଇନ୍ କୋର୍ସ
ରେଜିଷ୍ଟର ଫାଇଲ କରୁ ସେ
Wakalatnama be handed over to the land council who will file it before the registry got them. Matter will state next week.
I filed one discharge flag G.
That is there, but let it come next week.
Submit my friend discharge bail application.
The land council for the you have received the bail application. Yes. The land council for the petitioner stated that he has supplied the copy of the interim application for bail to also the date chart to the land council for the state. And he has also filed the date chart.
Not rejected earlier?
Earlier not rejected. Only one time interim bail granted for daughter's marriage 2 weeks.
In court which is taken on record.
It's order dated 19/8/2024. Order number 5. Sorry, 2014. Order number 5 में kindly be sir.
Order number 5, Justice Sahu's order.
Well, that is the reject.
No, he said that it has not been rejected, so it may shift matter.
Oh, that way.
Yes.
It was rejected earlier.
Whatever uploaded in computer, I saw only interim bail was uploaded.
No, that is not proper. Because you can say I don't know.
Sorry, my lord. Then
yes.
ତାପରେ ଆଜିକାଲି ସେ ୱାର୍କମ୍ ପାଖରେ ଥୁଆ ହଉଛି ଆପଣଙ୍କର ତ ଆପଣ ଦେଖିଦେବେ ଆପଣ ଗୋଟେ ସବମିଶନ କରିଦେବେନି ଆମେ yes next
It's rejected. ପୁଣି ଆଉଥରେ rejected on 14/12/2018 but judgment ନାହାନ୍ତି.
Item 4.
Item 4 minutes. May I humbly pray, my lord.
give you one offer letter because the file is missing, and I'm requesting my learned senior. If any time convenient to my learned senior, Lordship may kindly fix that. Today I'll reconstitute and Lordship may fix it. For tomorrow also, it will get prepared.
What do you want?
It's, the file is missing, so I'll reconstitute today itself, my lord.
The land council for the state submits that the matter may be. I'm usually taken up that week or the other. Put up this matter on 17th of
I'm obliged.
2000.
Item 5. Item 6.
You can collect the in your pen drive. Nobody is denying you. Have you got your pen drive? So collect it. IN number so and so. This is an application for bail. Mr. Patnaik, Land Counsel, appearing for the appellant, submits that he is not having the deposition copies, and further request to supply the soft copy of the deposition copy in his pen drive. The registry shall supply the deposition copies of the witnesses examined in the trial court to Mr. Patnaik in his pen drive. Hello? And the matter will be listed in the next week, 17th February 2025. ଆପଣ ଅଛି ତ ଡିପୋଜିସନ କରିଥିଲେ ଆରେ କହୁନାହାନ୍ତି କଣ ଆଶ୍ଚର୍ଯ୍ୟ ଷ୍ଟେଟ୍ କାଉନସିଲ ନେଇଯାଆନ୍ତୁ ଆପଣ ପେନ୍ ଡ୍ରାଇଭରେ ନେଇଯାଆନ୍ତୁ।
Item 7.
Item number 7. Item number 7, the director that the state has filed any appeal against the acquittal judgment.
Against?
The acquittal judgment.
What is this case? 302 or?
Yes, 302. The appeal has been preferred by the informant.
No, this appeal has been preferred by the informant. Right, but the division bench wanted to know from the state whether any appeal has been preferred by the state or not.
No appeal has been preferred.
There is no proposal also.
There is no proposal as well.
Have you got the written to that effect?
Yes.
All right. So file that, we can say so that because obviously if the state would have preferred any appeal, then both the matter would have been tagged together, right? So since you say that there is no appeal preferred by the state, nor the state has got any proposal.
Pending, and from the High Court website, we have verified there is no appeal pending or preferred by the state.
That's all right. So,
file an objection since there is 488 days of
all right.
delay.
As per the order dated, who order है state को objects में
11/12/2020.
No, that is for condonation of delay. आपण जो state appeal file करची कि नहीं
On 11/12 for the order, sir.
11/12. In the meantime, so on so acha. As per the order dated 11/12/2024, the Land Council for the state submits that no appeal has been preferred by the state against the impugned judgment and order of acquittal. And she further submits that the state has no such proposal also. So, बाकी आसନ୍ତୁ ବର୍ତ୍ତମାନ interim application.
काठ instruction आणले
Office has given the instruction.
Okay.
जे नो प्रपोजल से का ऑफिस संग देले
ମୁଁ ଆପଣଙ୍କୁ ବାରମ୍ବାର ପଚାରୁଛି ମ୍ୟାଡାମ ଆପଣ ଅସୁବିଧାରେ ପଡିଯିବେ ମୁଁ ସେଇଥିପାଇଁ କହୁଛି ଆପଣ
I'll take instruction from the concerned.
from whom?
From the PP or the
from the you see the proposal how it is rooted out ତାର ଗୋଟେ clear ହେଇଯିବା କଥା ଯେତେବେଳେ କୌଣସି Yes, yes.
हाँ रिकमेंडिंग 3 ही कर दिया
Okay, 3rd March 2020.
Item 8.
साथ रे appellant पे किए थे
No, not yet.
no counsel was there for the appellant in item 7 ଥିଲେ ପଳେଇଲେ
Non appears for the appellant.
On behalf of RN Behra, Chitrasan Naik.
अच्छा, you are there. ठीक है, साहब.
କହିବେ ନା ଗୋଟେ
But counsel for the appellant is present କରିଦେବେ. ତା ଦେହରେ
କିଏ
ଯୋଉ
ଚିତ୍ରସେନ ବେହେରା
item number 7.
ଚିତ୍ରସେନ ନାୟକ ହଉ ଠିକ ଅଛି
Yes, item number 8.
I number 2R75 of 2023.
ଆଗରୁ ରିଜେକ୍ଟ ହେଇନି ତ ହଁ କହିଲେ କଣ ହଉଛି ଏବେଠୁ ସେ ଆଇଏରେ ଗୋଟେ ଦେବେ ଗୋଟେ ଲାଇନ ଏବେ ରିଜେକ୍ଟ ହେଇଥିଲା କି ରିଜେକ୍ଟ ହେଇନି ପୁରା ଆମେ ତାଙ୍କ କାମ କରେ ତା ପର୍ସନାଲି ଆଗରୁ ଫିଲିଂ ନୋଟ ଦେଇଥିଲି ଏଇ ତାରିଖରେ ରିଜେକ୍ଟ ହେଇଛି
What is the offense for which you are facing trial?
302.
How many appellants are there? One. You are the only person who was facing trial.
In total case, 9 accused persons are there. Initially, 3 accused persons faced their trial.
ଆପଣଙ୍କ ଏଇ ଯୋଉ trial ରେ ଆପଣଙ୍କ ସହିତ ଆଉ କିଏ ଥିଲେ କି?
Yes, one of the co-accused are there. Then later, when the petitioner split the file was given, as required the advocate for the.
ଆମେ ଏଇଟା ଜଜମେଣ୍ଟ ଦେଖିକିନି ଆପଣଙ୍କୁ ପ୍ରଶ୍ନଟା ପଚାରୁଛୁ ଜଜମେଣ୍ଟ ରେ ଆପଣଙ୍କର ଏକୁଟିଆ ନାଁ ଲେଖା ହେଇଛି ତେଣୁ ସେ ଉତ୍ତରଟା ହବା କଥା ହଁ ତ କଣ ହେଲା ତାକୁ what is the offense for which you are found guilty?
The offense of section 302 of Act. Found guilty.
Okay, so come to the paragraph number 2 where the prosecution case is stated. Paragraph 2 of the judgment in page number internal page is 3. Please press it.
Until from the FIR on 10/6/2002, at about 1:30 p.m., the informant Sultan Manwar had been to the house of her husband's elder brother, namely Chala Manwar, with the deceased of this case. The FIR reveals that at the time, the deceased who had gone to market, they returned at the home. At that time, 9 accused persons, including the present accused, came there being armed with deadly weapons like Tangia, Jali, Baksha, and shots for the Diksha Nanwar, who happens to be the husband of the informant and brother of Salah. The accused, along with his associates, searched different places, destroyed the articles of the grocery shop, and directed the informant, the wife of the deceased, to produce Diksha Nanwar before them. In reply, the deceased stated Diksha Nanwar is absent in the house and ran away out of fear towards Social Loco Gate. When the deceased chased by the culprit, who surround him in the land of Lawrence Kena, and the deceased, as well as the culprits, were followed by the informant and his wife to the spot. It is further alleged that the accused William, along with his associates, killed Salah by assaulting him, then acts which the culprits were armed by that time. Seeing the occurrence and appearance of the culprits.
So, eyewitnesses are there.
Yes.
Who are the eyewitnesses?
The 1 and 2.
One is the injured and the
One is the injured. And 2 is another witness.
Both are eyewitness. One is the injured.
Out of which one is injured. And who is the doctor who conducted PM?
PW3.
PW3.
3 years.
So, PW3 is the doctor. Right? এটা কেতে নম্বর
assistant surgeon ঠিক আছে
criminal appeal 1011 one for the PW3 season
হ্যাঁ এটা না I'm working as assistant surgeon.
ST
Is
case
it
number
you?
44
It 3136 by
এটা কোনটা
2014
বার করছো তুমি?
তো ଅଛି ମୋର ତ ସେଇଟା ଫିଟୁଛି ବୋଧେ ନା ଟିକେ ଅଲଗା ନା ଏଇଟା ଆପଣଙ୍କ ଦେଖିଲେ ଅପିଲ ନମ୍ବର କଣ ପଡିଛି
ଆଉଥରେ କର
1011
ଆଉ ତାର ଯୋଉ ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡ ଅଛି PW3 କଣ ଲେଖା ଯୋଉଟା କାମିନୀ ନନୱାଲ ବୋଲି ସେଟା କଣ ଲେଖା
1011 ତ ହଁ ୱିଲିୟମ ସୋରେଙ୍ଗ ହଁ ଏଇଟା PCR ଏଇଟା ଠିକ ଅଛି ବୋଧେ ହଁ ଏବେ ଦେଖିଲେ ହେଲା
ସେଟା କୋଉଠୁ ବାହାରିଥିଲା?
That is PW3, that is the government number as well. That was
That
in
is the
respect of another.
SC case number 44
Yes.
of 2010.
ସେଟା କଣ ସେଟା ନୁହଁ
That is in respect of the other co-accusers.
ହଁ ଯେ ସେଟା ଆସିଛି କୋଉଠୁ ମିଳିଲା କୋଉଠୁ ସେଟା ଓ ଦିଟା ଜଜ ଡୁମ୍ ଡୁମ୍ ଏଇଟା ହେଲା ଆରଟା ଆଚ୍ଛା 44 ଟା ହେଲା ଆରଟା ଆଉ ସେ 44 ଟା କଣ
44 is the in
ରେସ୍ପେକ୍ଟ
of
ଅଫ
the
ଦ
other
ଅଦର
co-accusers.
କୋଆକ୍ୟୁଜ୍ଡ
Other co-accusers.
ସେମାନେ ବି ଆକ୍ୟୁଟେଡ
Someone acquitted.
ସେ ଆଗ ଆକ୍ୟୁଟେଡ ଇଏ ପରେ ଆକ୍ୟୁଟେଡ ନା କଣ ହଁ ତୁ ଇଏ ଗୋଟେ ବୁଲୁଥିଲା ପରେ ଆର ଟ୍ରାଏଲ
ୱିଲିୟମ ସୋରେଙ୍ଗ ଯେ ଆପେଲାଣ୍ଟ ସେ ଟ୍ରାଏଲ ଫେସ୍ କଲା କେତେ ନମ୍ବର କେସ୍ ରେ ST just a moment. ST 31 by 36 bracket ରେ capital A of 2014 ଆର ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡ ଟା ବାହାର କଲ ଦେଖିବା ଏଇଟା ନା ଏଇଟା 44 ଏଇଟା this is no
31 by 36 of 2014 ତା ଦେହରେ ୱିଲିୟମ ସୋରେନ ଟ୍ରାଏଲ ଫେସ୍ କଲା ନା ରାଜା ଡୁଙ୍ଗ ଡୁଙ୍ଗ
no William
Initially, Raja Dugna Wilson on the pressing trial is 31 by 36. Subsequently, Wilson split up
ଟିକେ ଟିକେ
31 by 36 bracket the A.
ତ ଜଜମେଣ୍ଟ ଟା ଦେଇନାହାନ୍ତି ଆପଣ ଏଟା ଦିଟା ଜଜମେଣ୍ଟ ଦେଇଛନ୍ତି କପି ଅଫ ଜଜମେଣ୍ଟ ଏଠି ଦେଲା ଠିକ ଅଛି 31 36 A ମାନେ ଦଳେ ଦଳେ ଆସିକି ଥରେ ଥରେ ଟ୍ରାଏଲ ଫେସ୍ କରିକି ଯାଉଛନ୍ତି ଭେରି ନାଇସ୍
31 ନା କାହିଁ ଇଏଟା କାହିଁ deposition copies
The position copy in this case is submitted by way of a memo.
PW1 2 3 4 what ଆପଣ ଯୋଉ ଡେପୋଜିସନ ଦେଇଛନ୍ତି ତା ଦେହରେ ଏ ତ ଲେଖା ହେଇନି
Till PW4.
ସବୁ ମିଶିକି ହେଇଥିଲା ତାପରେ ସ୍ପ୍ଲିଟ୍ ଅପ୍
Yes, PW5.
ନା PW5 ଲେଖିଲେ କିନ୍ତୁ ସେଟାରେ ବି ଏ ଲେଖା ହେଇନି କାଇଁ ଆପଣ ଯୋଉଟା ଦେଇଛନ୍ତି ତା ଦେହରେ ଏ ନାହିଁ ଆରେ ଆମକୁ ଯୋଉଟା ଦେଇଛନ୍ତି ଆପଣ ମେମୋ ସହିତ ଦେଇଛନ୍ତି ନା ଉପରେ ହେଡିଂ ଟା ଦେଖନ୍ତୁ
ଆପଣଙ୍କର କେସ୍ ରେ ଯୋଉ ଜଜମେଣ୍ଟ ଟା ହେଇଛି PW1 ଲେଖା ହେଇଛି କର୍ମୀ ନାନୱାଲ ହେଲା 2 ହଉଛି ପୁଷ୍ପା ନାନୱାଲ ପାଇଲେ ନା ଜଜମେଣ୍ଟ
ହଁ ଏଇଟା
ଜଜମେଣ୍ଟ ଏଇଟା ଆକ୍ୟୁଜ ହଉଛି ଏଠି
ହଁ ସୋରେଙ୍ଗ
ହଁ ସୋରେନ୍ ଲାଷ୍ଟ
Witness
କେସ୍
ଟା ପଚାରିଥିଲୁ
ଲାଷ୍ଟ କେସ୍ ସେ वकालत नंबर क्लिक करते सब पूर्व ତାହେଲେ ତାର ଏଇଠି ହଉଛି PW1 ହଉଛି ଏଇ କେସରେ କର୍ମୀ ଡକ୍ଟର ହଉଛି PW3 ତାର ଡିପୋଜିସନ କପି କାହିଁ
ସେ ଅଛି ତାପରେ ତଳେ ଆଉ ଏଇଠି ଆଉ ତଳକୁ ପଳଉନାହାନ୍ତି ଆଉ ତଳକୁ ପଳେଇନି ସେଥିପାଇଁ ମୁଁ ପଚାରିଲି ତା ଦେହରେ ଏ ପଡିନି ସେ କହିଲା ସେତିକି ବେଳେ ଯାଏ ସବୁ ମିଶିକି ଏକ୍ସାମିନ ହଉଥିଲେ ତାପରେ split up ହେଲା।
Yeah, you know, so there are incised wounds, 1, 2, 3, 4, fracture of left parietal and fracture of left mandible, so on, so fracture of left maxilla, all these things. On dissection of the scalp, I found a laceration of the parietal lobe of the brain. I also noticed incision of this also. And the cause of death was hemorrhage and shock due to incision of the common carotid artery and injury to the brain. So the evidence is PW1 person. Eyewitness कौन पहला? PW1 पहला. William Soren dealt me a push and tried to kill me by means of an axe. Ratho Soren, however, intervened and I was saved. Out of fear, I went along with 5-year-old son outside, hid myself in a field which situated behind my house. Deceased to Marla. Opposite came to my response. When I said I did not know anything, they entered inside my house and out of suspicion and search for them, they ransacked even if I was pregnant.
May I please?
Who paragraph रे अच्छी assault को था deceased को?
Paragraph 2 years.
2 रे.
Paragraph
Body ले पढ़ ले.
Next day at around 1 p.m., when the deceased was arranging the grocery articles of his shop, which were kept inside his shop room, the present accused persons, along with the associated person, came being armed with axes and fasteners and tried to enter inside. The deceased slammed the door of the shop room. The present two accused persons, along with the others, tried to enter into the shop through the asbestos roof thereof. The deceased, out of fear, opened the door of his shop room and ran towards the field nearby. The present two accused persons and their associates broke a portion of the roof, the shop room, and then jumping off, chased after the deceased. They caught him at a distance of 15 meters from the shop room and accused William Raju Dungdung and their associate killed him. They killed him by dealing axe and fasa blows. Paragraph 3. I could see the incident since the last night I had taken shelter in the house of the deceased. After the deceased died, the present two accused persons and their associate went in search of my husband with a view to killing him. I came to know.
So similar is the evidence of PW2.
PW2.
That means these two who are facing trial, that means the appellant and another, along with others, they assaulted the deceased. And that too by axe and farsa. So what happened to those persons who were earlier faced trial?
So they were acquitted. So kindly see page 4 of the impugned judgment. That shows the conduct of the appellant as well as the others. May I read it?
Page 4.
Page 4 of the.
Yes.
The last paragraph, third one. Subsequently, may I read it? Subsequently, the accused Jogi Nanwar, Sanjay Kirketa, Peter Varla were arrested and they faced trial in ST case number 44 of 2010 and were acquitted. Subsequently, the present accused and Raju Dungdung, after being arrested, were committed by the learned JMFC Rajgan for trial of the case to the Court of Sessions. On 22nd 7, 2017, the accused William absconded and case record was split up against him. The case against the Raju Dungdung proceeded and finally he was also acquitted in the Court of Additional Sessions, Sundargarh and Swansea.
No, it's all right, sir. One thing is that, let us say he absconded, but the witnesses, your witnesses have implicated not only those acquitted persons, but also this petitioner. So, how do you say that the petitioner is solely responsible for the death of, in what way?
PW1 and 2, there are consistent evidences that he was holding an axe and he has dealt axe blows. And
not only PW1 says that not only he, but along with others, those who faced trial.
Yes.
And they were also armed with, he has stated that the present two accused persons along with their associates came being armed with axe and farsas.
Yes.
And then inquired and then they chased and assaulted. So all of them assaulted.
All of them. For that,
So question is that merely because somebody is absconding and he subsequently he was arrested, can that be a ground to convict him?
that should not be arrested. But PW 1 and 2 constantly say that they have seen the accused person assaulting the deceased by means of acts for which he has sustained injuries, and out of that injury he has died. That is confirmed by the PW 3 with the PM doctor. That is the circumstance.
PW 1 and 2 have named this appellant.
Yes, sir.
ସେ appellant ଏବଂ ସେମାନେ
I've just
ଯୋଉମାନେ
placed it.
acquittal
Yes,
ହେଇଗଲେ
PW 1
ସମସ୍ତଙ୍କୁ
one
include କରୁଛି. All of them have assaulted. And he has named those persons who have been acquitted that they were also there and they
with
also
weapons.
armed with weapons
Weapons.
and they assaulted.
Yes.
So if we keep those judgments that first of all 3 accused persons face trial, then another person face trial against whom same allegation is there. So merely what you are pointing out that this man was an absconder. He was on bail and subsequently absconded.
There's 2 segments. One is they both the eyewitness out of one was the injured eyewitness. They implicate the present appellant. As well, the PW3 is the doctor.
These 2 persons and the associate. So ତାଙ୍କୁ ଏମିତି omnibus ରେ
He was the main assailant.
specifically. Para PW2 para first paragraph. I know the present accused person and I saw and their associate killing the deceased.
Associate ମାନେ ଉପରେ ତା ନାଁ ଗୁଡା କହିଛି.
हाँ ଦେଇଛି.
By the way, when you were taken into custody? Yes.
After they were acquitted or before?
He was the date of offense is 2002.
Wait.
Date of occurrence is
In
10/6.
absconded, that is the problem. Huh.
He absconded also. He got arrested on 25/1/2014.
Date. First arrested
25/1/2014.
Yes.
Thereafter, he was released on bail. Then he absconded. Then again arrested on 26/5/2022. Thereafter, this present judgment has been passed.
Okay.
So that means what is your period of detention? If that is correct, then it may not be 3 ବର୍ଷ ଖଣ୍ଡେ ହବ. ଆପଣ
given by the appellant.
2022 କୁ ଯଦି ଆରେଷ୍ଟ ହେଇକିନି ଅଛନ୍ତି 26/5/2022 ତ 2 ବର୍ଷ ଏମିତି ବି ହଉନି. ବାକି ହଉଛି 3 ବର୍ଷ ହଉନି ଆଉ ବାକି ସେତେବେଳେ ଯାହା ଯାଇଥିବେ ପ୍ରଥମେ. So where is your date chart and have you mentioned when you were arrested, when you were released on bail?
I was from date chart given by the appellant.
Date chart है.
25/1/14 arrested one.
ना सेमती होनी अपन bail. Then you produce the custody certificate.
Yes.
That will be known that.
12 ବର୍ଷ you were absconding.
14 ରୁ
Thereafter they flouted the bail
14
order
ରୁ
and
22 ମାନେ 8 ବର୍ଷ ପାଖାପାଖି.
Second time I have not asked.
नहीं date of offense पर 2002.
हाँ date of occurrence ରୁ 12 ବର୍ଷ ପରେ ତାପରେ ପୁଣି abscond. ଏଟା ହଉଛି.
Second time I have not asked. My conducting counsel did not take any step.
So he absconded.
Non-bailable warrant of arrest was issued. So
immediately you surrendered.
ନାଇଁ
ସେ କହୁଛନ୍ତି କାଉନସିଲ ଭୁଲ କରିଦେଲେ ତ ଜାଣିଲା ପରେ କାଳେ ସାଙ୍ଗେ ସାଙ୍ଗେ ସରେଣ୍ଡର କରିଥିବେ ସେଥିପାଇଁ.
Your date of when the NBW was issued?
Issued on 22/2/2017.
ତାହେଲେ 17 ରେ NBW ଇସ୍ୟୁ ହେଲା ଆପଣଙ୍କର 22 ରେ ଆରେଷ୍ଟ ହେଲେ. ଆପଣ ମାନେ ଭୁଲି ଗଲେ ଯେ ଗୋଟେ 302 ଟ୍ରାଏଲ ଫେସ୍ କରୁଛନ୍ତି ଆପଣ ଷ୍ଟେପ ନେଲେନି ତାପରେ ଆପଣ ଓକିଲଙ୍କ ସାଙ୍ଗରେ ବି ଯୋଗାଯୋଗ କଲେନି ସେଇଥିପାଇଁ 5 ବର୍ଷ ଇଆଡ ପଳେଇଲା ବାହାରେ ରହିଗଲେ. ତା ପୂର୍ବରୁ ତ 12 ବର୍ଷ ରହିଥିଲେ ଘଟଣା ପରେ ଆପଣ ନା ରାଜକଣ୍ଡର ହେଇକି ଚାର୍ଜସିଟ୍ ହେଇଥିଲା ବର୍ତ୍ତମାନ ତାପରେ ଏଇ ଟାଇପ ର
କେବେ ବେଲ ଗଲେ ଡେଟ୍ ଚାର୍ଟ ଗୋଟେ କିଛି ଦେଇନାହାନ୍ତି.
ବେଲ ଡେଟ୍ ଚାର୍ଟ ଦିଆହେଇନି. You file a detailed bail date chart indicating about when you are granted bail. Okay. And NBW issued all these things and also you produce that custody certificate. The learning counsel for the IN numbers one.
If the supply the judgment in the other cases so that I can examine on what basis the others are acquitted.
ଦେଇନାହାନ୍ତି କି ଅଛି ରେକର୍ଡରେ?
You have got the copies of them?
Yes.
just hand over.
अरे कोर्ट को जा दोचन ताकि भी दोथे
दिथर दीटा सेट अक्यूज ट्रायल फेस करिसेंती अक्यूटल हेचंती यू आर दी आपण तृतीय थर पई ट्रायल फेस करी कन्विक्शन हल अच्छा so you see that if there is any distinguishing feature between this
Alex,
apart from absconding to say one look the learning council for the appellant submits that he will file a date draft indicating the date of release of bail of the petitioner and date of issuance of non-bailable warrant of arrest, etc. And counsel for the state submits that she will also obtain instruction. She will produce the custody certificate on the put of this matter. Let it come on 3rd of March 2020. Yes.
तो फर्स्ट जो जजमेंट हला सेटा टोटल डिफरेंट ट्रायल
Trial.
सेकंड रे अधा
এই witness মানে মধ্যে examine ହେଇଥିବେ
এই যে অলগা সিরিয়াল নাম্বারটা অলগা আছে
you see the have you examined it the what is the witness version in that trial
have they supported the prosecution case
Supported by the commission and contradictory statements are passed on the basis of the contradiction and omission. They all are acquitted.
सब एड़ा सब
you see if the those this very same witness has earlier deposed in connection with this case in a sessions trial which has been faced by the co-accused persons. It is your paramount duty to examine those statements also and whether it can be utilized under section 391 for taking additional evidence. Jadi got a witness, suppose X is a witness, he has deposed thrice, right? Thrice रे गोटे फास्ट रे आपन को एक्सोनरेट करछि बा अन्य मानु कर जोत में एक्यूटल हेछि सेकंड रे भी जो एक्यूज संगे फेस कला ट्रायल ताकू भी किछि कहला नै थर्ड टाइम आसिकिनी आपन को ना कहूछि जो डिफेंस काउंसिल प्रथम दायित्व थिला जे एग्जामिन करिवार जे से जो प्रथमे दुई थर जो को-एक्यूज को पई जो स्टेटमेंट देछि तार स्टेटमेंट कोन थिला हला से ऑर्डर ऑलरेडी तांको फेवर रे जाई सो देयर मस्ट बी समथिंग ताकू कंपेयर करिकिनी तांको क्रॉस एग्जामिन करिवार थिला विथ रेफरेंस टू दोज अर्लियर स्टेटमेंट व्हिच हैज बीन गिवन दे आपण जेतेबेले ई को-एक्यूज फेस करथिले आपण सेतेबेले मध्य आसिकिनी देइथिले पीडब्ल्यू1 हिसाब रे आपण ई जो कहउछंती वर्तमान एमानको ना सेटो कहि नथिले तापरे तां कन्फ्रंट करिकिनी सर्टिफाइड कॉपी ऑफ द डिपोजिशन कॉपी should have been filed to mark as an exhibit. That is the procedure adopted. So if that has not been done, then the way out is to file application before this court also to take it as additional evidence. सेठी मध्य आपन को निया ही परिबो the matter would be remanded for this or the appellate court can take also the evidence for this limited purpose. Questionnaire set कर दवा पड़ो उन तक एग्जामिन करिवार अछि ये जो 1 and 2 जहा बेसिस रे आपन को कन्विक्शन है छी सेई 1 and 2 जदि अर्लियर ट्रायल कोर्ट रे जो को-एक्यूज्ड को पई एविडेंस निश्चय देइथिबे तनु तांकू एग्जामिन करतो से माने कोन से एविडेंस देइछन हला दैट इज द वे आउट हला ऑलराइट नेक्स्ट
Item 9.
Again, I am appearing on behalf of the victim minor, but counsel for the petitioner, Mr. Vishwa.
is this matter what a date the event you should start for it the land counsel for the you are appealing for the victim is present and the land counsel for the only a mention is made on behalf of a mention is made on behalf of the appellant Rajan. Yes.
Item 10.
Who is appearing?
I'm for the include.
You are for the informant.
Yes, sir.
Okay. So it has not been admitted. What is the offense here? Yes. Where is your with the council? No. Why are you moving this bail application?
Yesterday, my lord, the husband, my lord, appellant number 2, my lord. Husband of the appellant number 3, my lord. Died, my lord, during treatment in SU medical. Earlier, I filed a interim bill for illness of the.
Okay. We have to decide what is the IA number?
IA number, my lord.
362 of 2025. No. 346.
362.
Huh?
362 of 2020.
362 of 25 at flag G.
flag.
Where is that affidavit where you said that your husband has died? Yes.
Memo, plot, document, memo.
So, कौन आपको instruction कौन? Correct.
ये 3 ମାସ ଯିବ ଆଚ୍ଛା ତାର ଦେହ ଖରାପ ଥିଲା ପିଲା କିଏ କଣ ଅଛନ୍ତି? ପଢିଛି କଣ?
ये जो डेथ प्रोफेशन को पेशेंट देवेंद्र पति स्वान सिंह patient is initially treated but desperately.
Husband wife both Indian.
Why leave available application?
And it is basically for the nature of the Devara supplementary report as well.
Obsequious ceremony for your
2 weeks minimum.
of 2025. There is an application for interim bail filed by appellant number 3, Delhi alias Itisri Pati. On the ground that her husband, who is appellant number 2, suffered from brain stroke and cardiac problem and has been admitted in SC Medical College Hospital, Cuttack, for surgery. Today, during the mention hour, this matter was mentioned on the ground that the appellant number 2 has expired while undergoing surgery in SC Medical College Hospital. And in view of the urgency, we directed the matter to be listed today. However, it was brought to our notice that on 6/2/2025, the Honorable Acting Chief Justice has passed an order that the matter is to be listed before a division bench where Honorable Justice B. Narsingh is a member. The matter was again placed by the Deputy Registrar Judicial before the Honorable Acting Chief Justice in view of the memo mention memo filed by the Land Council for the appellant and stating that about the death of the appellant number 2 who was undergoing surgery.
Treatment.
It is surgery. Cardiac surgery died. The Honorable Acting Chief Justice has assigned this bench to take up the matter. Deputy. The Land Council for the appellant has filed a memo wherein it is stated about the death of the appellant number 2 on 11/2/2025. The Land Council for the state also has obtained written instruction from the assistant professor so and so eco unit CTVSSC Medical College Hospital Quarter, wherein also it is mentioned that appellant number 3 Devendra Kantana Patil Pati died on 11/2/2015. The memo and the written instruction obtained by the Land Council for the state are taken on record. Land Council for the petitioner submits that in order to perform the obsequious ceremony of her husband, the presence of the petitioner is necessary. After hearing the Land Council for the respective party, the ground produce that is taken on record. We are inclined to release the petitioner on interim bail for a period of 3 weeks.
Material done at the police.
One month.
Sure. 4 weeks.
Pardon me, if without to provide the bail bond manner,
No. We will without providing bail bond, how will be released from custody?
If the lordship may directed to jail.
You have to provide the bail bond. We do not know that. You have to arrange the surety at least. We can say that you one surety you can say, but you have to arrange the bail bond. Not they can say 302 case life imprisonment agency. It may be 1 day late. What is there? So you have granted bail. So yes, order will be available to you within a few hours.
Today, man. Course of day, man.
Yes.
Sorry, no.
Why are you in a hurry?
The
The Land Council is making a submission. Why are you in a hurry? Yes, and matter be listed on such and such the Land Council for the appellants will produce the surrender certificate of ownership. This secure for you now.
I was just wondering if you mention any item number 10 and
it has been adjourned. And it will be taken up on.
Sorry for that.
It is posted to 3/3/2020. Yes. जो ଗୋଟେ କଣ ନନ୍ ଆଫିୟର୍ସ କଣ କରାଯାଇଥିଲା ବୋଧେ ସେଟା କାଟିଲି ଏମିତି है ना आइटम नंबर 10 ରେ କିଛି
Madam, special item document directive online copy may be utilized by the court below.
এইটা ଗୋଟେ লেখা the line টা লেখিলো that it will be uploaded and the Land Council the Land Trial Court shall accept the bail bond on the uploaded copies in the High Court website. After taking an undertaking from that, you will probably be certified copy.
within a week.
Within a week.
ଆପଣ ବି ଗୋଟେ ଜେଲ କୁ ଗୋଟେ ଜଣେଇ ଦିଅନ୍ତୁ ଯଦି ଅର୍ଡର ଟା ହେଇଛି why not help her.
Intimation shall also be given to the by the Land Council for the state.
Was in jail, Bhadrak jail. Bhadrak jail. He was referred to from the jail custody from Bhadrak jail.
All right.
ବଡି ଯାଇଛି ସେଇଠି ନା କଣ?
No, Bhadrak jail ରେ
Yes.
petitioner is now in Bhadrak jail.
Yes. Which item? Yeah. What's your topic?
Hmm?
2 minutes.
The additional note of submission with citation.
ସେ ଯୋଉ ଶୁଣା ହେଇଥିଲା ସେଟା
Please take your seat. The CRL number 21 of 2008. The appellant Patro face trial for commission of offense under section 302/34 of the Indian Penal Code in the court of Learning Sessions Judge Fulbani in Sessions Trial number 69 of 2006 on the accusation that he, along with his son Sahadev, in furtherance of their common intention, committed murder of Dhiren Mandal, bracketary hereafter the deceased, on 5/8/2005 at about 8 p.m. at Chechingia Nala in village Mundigada. Under Tumudibandha police station in the district of Kandhamar. Stop. The Learning Trial Court by judgment and order dated 9/1/2008 found the appellant guilty of the offense charged and sentenced him to undergo imprisonment for life. On 6 subpara, on 6/8 on 6/8/2005, PW4 Bono Singh Mandar lost the first information report before the officer in charge of Tumudibandha police station, wherein he has stated that on 5/8/2005 at about 8 p.m. the appellant along with his son Sahadev Patram and their other family members have committed murder of the deceased near Changia
canal by assaulting him with Tangier. PW4 further stated in the first information report that he received the information from Gramrakhi Ikka Pradhan, bracketed PW3, about the incident, who told him that it was the wife of the appellant who gave him information regarding commission of murder of the deceased by the appellant. Stop. On the basis of such first information report, PW10 Harihar Swain, the officer in charge of Tumudibandha police station, registered Tumudibandha PS case number 49 of 2005 and took up investigation of the case. Stop. During course of investigation, the IO examined the informant and deputed his staff to guard the dead body. Stop. He himself reached at the spot at about 9:50 a.m., prepared the spot map, bracket exhibit 12, held inquest over the dead body in presence of witnesses and prepared inquest report, bracket exhibit 13, and then sent the dead body for post-mortem examination to the sub-divisional hospital. He also seized the sample earth and bloodstain earth from the spot as per seizure list exhibit 4. He examined other witnesses and apprehended the appellant at 5 p.m. on 6/8/2005. On 7/8/2005, at about 7:30 p.m., the IO seized the wearing apparels of the deceased on being produced by the escort party members who had accompanied the dead body for post-mortem examination. The appellant was arrested, and while in police custody, he volunteered to give recovery of the weapon of offense, that is axe, and accordingly his statement was recorded by exhibit 2/2, and he led the police party and the witnesses to Chachingia Nala and gave recovery of the axe and produced the same before the IO, which was seized as per seizure list exhibit 3. The wearing apparels of the appellant were also seized at the police station as per seizure list exhibit 7. The IO sent the appellant to SD hospital
for collection of his nail clippings and accordingly the same was collected and produced before the IO, which were also seized. Stop. The IO received the post-mortem report and sent requisition to the SDMO Baliguda, making a query relating to the possibility of the injury sustained by the deceased with the weapon seized, and received the answer in affirmative. On 17/9/2005, the IO prayed before the SDGM, Learned SDGM Baliguda, to forward the exhibits to SFSL Rasulgarh, Bhubaneswar, for chemical examination. On completion of investigation, charge sheet was submitted. Trial court report of Harkeli. Under section 302/34 of the Indian Penal Code against the appellant and Shahdev Patron, the son of the appellant, suing the latter as an absconder. After submission of charge sheet, following the due procedure, the case was committed to the Court of Session, where the Learned Trial Court framed charge as aforesaid. Since the appellant pleaded not guilty and claimed to be trial, the sessions trial procedure was resorted to prove his guilt. Subpara. In order to prove its case, the prosecution examined 10 witnesses. The prosecution also proved 16 documents and 6 material objects. The defense plea is one of denial, and it is stated that on suspicion he has been falsely implicated in the case. Next para. The Learned Trial Court, while assessing the evidence of the witnesses, has observed in the impugned judgment that there is no direct evidence in the case, and the case entirely depends upon circumstantial evidence. Taking into account the last scene of the deceased in the company of the appellant, as deposed to by PWs 1 and 2, the information given by the wife of the appellant to Gramarokhi that the appellant had killed the deceased near Chachinga Nala, as deposed to by PW3, the dead body of the deceased was found lying near Chachinga Nala with head injury, leading to discovery of the weapon of offense axe at the instance of the appellant from inside a bush, as deposed to by the IO, the medical opinion about the possibility of the injury sustained by the deceased
with such weapon. So also possible time of death of the deceased with the time of incident as deposed to by the Dr. bracketary PW9, the London Trial Court has been pleased to hold that the witnesses who have deposed to support the prosecution case are all reliable, and even though there is no direct evidence, the circumstantial evidence available on record are sufficient to hold the appellant guilty under section 302 of the Indian Penal Code. The Ms. Tapaswini Sinha, Land Counsel for the appellant, contended that the London Trial Court has not kept in mind the well-settled principle of appreciation of a case based on circumstantial evidence. She argued that the last seen evidence which has been adduced by PWs 1 and 2 are discrepant in nature, and therefore the London Trial Court should not have placed reliance on these testimonies. It is further argued that though it is the prosecution case, that the wife of the appellant came to PW3 and told him that the appellant has committed murder of the deceased, but in absence of the examination of the appellant's wife during trial, the evidence of other witnesses, the evidence of PW3, who stated to have heard it about the incident from the appellant's wife, becomes the hearsay evidence, and it is inadmissible. Land Counsel further argued that the information given by the appellant's wife to PW3, which he in turn disclosed before the informant, bracketary PW4, is also highly suspicious in as much as neither in the first information report the said aspects find place, rather it is mentioned in the FIR that the petitioner, that the appellant, his son, and his family members have committed murder of the deceased. The Land Counsel further argued that though at the instance of the appellant, the weapon of offense, that is an axe, is stated to have been seized, which is deposed to by the IO bracketary PW10. But the independent witnesses to such seizure, that is PWs 4 and 5, 4 and 5, na? Huh?
5 and 6.
5 and 6 have not supported the prosecution case. And moreover, the weapon of offense has not been shown to PW1 to be identified in court. It is argued that the
evidence is lacking that the dead body was found at the place where the appellant and the deceased were last seen. And therefore, on the basis of the available material on record, it cannot be said that the chain of circumstances is so complete so as to unerringly point towards the guilt of the appellant, and therefore it is a fit case where benefit of doubt should be extended in favor of the appellant. Land Counsel, Mr. Jateshwar Naik, an additional government advocate, on the other hand, supported the impugned judgment and argued that the London Trial Court has rightly placed reliance on the evidence of PW 1 and 2, who have seen the appellant and the deceased indulge in quarrel, and the appellant was armed with an axe, and the axe was seized at the instance of the appellant as deposed to be by the IO, and it was sent for chemical examination, and the C report indicates that human blood was detected on it. The Land Council further argued that the circumstantial evidence which are appearing on record against the appellant is trustworthy, and it has been rightly relied upon by the Lenin Trial Court. And the doctor who has conducted post-mortem examination has noticed the doctor is PW 9. The doctor bracket like PW 9 has noticed the injuries on the parietal region and opined the cause of death to be homicidal in nature. And he has also answered to the query made by the IO that the injury found on the head of the deceased was possible by the axe bracket MO4, which was produced before him after its seizure. And therefore, the chain is complete and the appellant has been rightly found guilty under Section 302 of the Indian Penal Code. Adverting to the contention raised by the London Council for the respective parties, let us examine the materials available on record to see whether the prosecution has successfully established that the deceased met with a homicidal death or not. Apart from the inquest report, bracket Exhibit 13, the evidence of PW 9, Assistant Surgeon, SD Hospital, Baliguda, is very much relevant. PW 9 conducted the post-mortem examination on 6/8/2005, and he has noticed the following external injuries. Quote for those. And he further stated that the cause of death was due to hemorrhage and shock and injury to the brain, and the death might have occurred within 12 to 36 hours. And it is a case of homicidal death. The Postmortem report was marked as Exhibit 9 with objection since the original was not produced. It further appears from the evidence of PW9 that on 15/9/2005, the IO made a query to him regarding possibility of the injury found on the head of the deceased by the weapon, that is axe oblique tangia, produced before him, and on examining the axe, the doctor opined in an affirmative, and the query report has been proved as Exhibit 10. Nothing has been brought out in the cross-examination to disbelieve the evidence of the doctor. The Learned Counsel for the appellant has also not challenged the evidence of the doctor and his opinion regarding homicidal death of the appellant. After going through the evidence on record, more particularly the inquest report, the postmortem report findings, the evidence of PW9, we are of the view that the Learned Trial Court has rightly held that the deceased met with a homicidal death. Admittedly, the case is based on circumstantial evidence. The principle of appreciation of circumstantial evidence is well settled in the case of so and so Sarad Vichan Sardar case delivery. In the case in hand, the first circumstance relied upon by the Learned Trial Court is the last scene, which is deposed to by two witnesses, that is PW1 and PW2. PW1 has stated that on the date of occurrence, he was tending cattle on a piece of land in his village, and it was evening hours, and he saw the appellant and the deceased were indulged in quarrel. However, the son of the appellant was not there, but the appellant was holding an axe. He further stated that the appellant had got land where the aforesaid incident occurred, and on the next day he heard that the deceased was lying dead near the spot where they were quarreling. However, he has stated that he had not gone to the spot to see the dead body. He further stated that PW2 was in his land at the time of incident. In the cross-examination, he has stated that he was about 400 feet away from the deceased, and further stated that he could not say who was holding what weapon and why they were creating disturbance, why they were quarreling. PW2, on the other hand, though stated that the appellant and the deceased were together, But he has not stated that there was any quarrel between the two. Rather, he stated that from their gestures, he found that they were talking. He also has not stated that the appellant was armed with any weapon. He further stated that on the next day, he heard about the death of the deceased near the spot, but he had not gone there to see the dead body. The dead body of the deceased was found in the land of one Bamon Patra, as per the spot visit note prepared by the investigating officer, where the inquest was also held. However, the evidence of PW 1 and 2 is completely silent that the appellant and the deceased were found together in the land of Baman Patra. Since there are discrepancies between the evidence of PW 1 and 2, in as much as the evidence of PW 1 that both the appellant and the deceased were indulged in quarreling and that the appellant was holding an axe is not getting corroboration from the evidence of PW 2, and they had not shown the spot of quarrel to the IO. Therefore, it is very doubtful that these circumstances to be utilized as larceny. The law is well settled that the evidence of the larceny can be utilized in a case where the larceny and the finding of the dead body is in a close proximate of time, and the chance of the deceased coming in contact with any third person is ruled out. In absence of such evidence, we are of the view that the learned trial court aid in utilizing the evidence of PW 1 and 2 as the larceny of the appellant with the deceased. So, the evidence of PW 3 is that on 5/8/2005 at about 8 p.m., while he was in his house, the wife of the appellant came to his house and told him that her husband had caught the deceased. And when he asked the wife of the appellant whether the deceased was dead or alive, she told that the deceased might have died in the meantime. PW3 in turn informed the same to PW4. Whereafter, PW4 went to lodge the first information report. Most peculiarly, in the first information report, there is nothing that the wife of the appellant had given any such information that the appellant killed the deceased. Rather, it is mentioned that the appellant, with his son Sahadev Patra and his family members, have killed the deceased with Tangia. In view of such recital in the first information report, which was lost by PW4, the so-called information stated to have been given by the wife of the appellant becomes a doubtful feature. Moreover, the wife of the appellant has not been examined. Therefore, the evidence of PW3 becomes hearsay and it is not admissible in view of Section 60 of the Evidence Act. The weapon of offense was seized as per the disclosure statement made by the appellant, which is deposed to by PW10. And he has stated that after arresting the appellant, while he was in custody, he stated that the weapon of offense, that is axe, had been kept concealed at a place, and he would show that place if he is taken to the place of concealment. Accordingly, he led the IO PW10 and the witnesses to Chachinga Nala and then to a bush wherefrom he brought out one axe. The IO proved the statement of the appellant recorded under Section 27 of the Evidence Act, which has been marked as Exhibit 2/2. And after recovery of the axe, a seizure list has been prepared by Exhibit 3. PW5 and PW6 are the witnesses to such seizure, but they have not supported the prosecution case. PW5 has stated that the police insisted him to sign on papers even without knowing why he would sign the same. And accordingly, he signed. PW6 has also stated that police took his signature on the white and blank paper. Uh, the even if this ax was examined by the Dr. Bracketry PW9, who has given his opinion that the injury sustained by the deceased was possible by such weapon, and human blood was also found in the ax as per the C report, but in absence of any other circumstance being proved, this circumstance alone is not sufficient to hold the appellant guilty. Accordingly, we are of the view that the prosecution has failed to establish the charge under section 302 of the Indian Penal Code against the appellant. Accordingly, the impugned judgment and order of conviction of the appellant is set aside, is acquitted of the charge. The appellant is in jail custody, shall be set at liberty forthwith if his detention is not required in any other case. He is on bail. Okay. If appellant is stated to be on bail, all right, the bail bond and the surety bond stands cancelled. And you are appointed as amicus curiae or you are legal aid?
No, madam. From the legal aid.
Legal aid. Legal aid.